No, madam.
Then
After notice.
after notice cannot come. It will be listed after Puja holiday. Don't mention.
Yeah, ordinance, madam.
No, every case has urgency. Yes.
Secretary matter or it is fresh matter?
Fresh matter.
Yes.
Fresh matter, yeah.
Supplemental list, item number 1.
Note study. Yes. Please.
My lord, I'm grateful your lordship provided me an opportunity to go
You
through
just
again.
come to this side so
Madam.
that it will be.
Supagito airport pore. I'm grateful to my lords that my lord had provided me an opportunity to again revisit the case. My lord, I humbly pray your lordship that I take up the paperwork at the cost of repetition also. I want to
You're-
place.
You're holding?
Yes. My lord, may kindly turn to page 79 and will place again from the evidence because I prepared in that way.
79.
Yes. Now, this is the deposition of PW1. PW1 was the person who had taken the minor child of the accused to temple.
Accused and deceased.
Yes, yes. Minor child of the couple. I'm sorry, madam. Minor child of the couple to the fateful day of the incident.
Right.
My lord, will see at page 79. Paragraph 2. I went with the son of the accused to the temple and we returned at about 11 am. We saw police personnel and other accused had gathered there in that quarters. We learned that the wife of the accused had set her ablaze in the bathroom and as such committed suicide. Now your lordship may kindly turn to the next page. Cross-examination by the after returning. Yes, perfect. After returning from the temple, I came to know that the deceased has committed suicide by bolting the door from inside. I further came to know that the local people broke open the door and came to know about the occurrence. There was a ventilator in that bathroom, and after breaking open the glass of the ventilator, people tried to enter the bathroom when they failed to open the door. Now, there's one thing your lordship may also. Of course, he was not present at the spot. He was outside because he had taken the minor child to temple. But he in the cross-examination, he has fortified the fact that there was a ventilator in the bathroom and after breaking open the glass of the ventilator, people tried to enter the bathroom when they failed to open the door. Now, this is this that the glass ventilator was broken was PW2. Now, your lordship may kindly see PW2. My lord may kindly see at page 83. Fourth line from the petitioner 2. PW2. Yes, ma'am. Page 83. Fourth line from the top. In the cross examination. Yes, ma'am. Yes. When the defense, when the prosecution cross-examined him, this is fourth line from the top. It is a fact. It starts with the words, it is a fact. It is a fact that I have stated before the police that immediately after use of obscene language by the accused raised Halla, Porigala, Porigala. It is a fact that I had stated before the police that we followed the accused to the bathroom. It is a fact that I have stated before the police that I and one Rockaway threw water towards the ventilator of the bathroom. And this person who is Rockaway was never examined by the prosecution. Though he was present in the house at the time of the alleged occurrence. I and one Rockaway threw water towards the ventilator of the bathroom that accused and one Kishore. Now, that Kishore या लक्ष्य में kindly mark, he was BW1.
But it is not consistent one.
No, BW1.
It was saying as if the ventilator was broken open and
No,
people.
no. He was not present at this point.
That is how it was story for him.
No, he was not present at this point. He heard it.
So that is an exaggeration fact.
He has heard it. And PW2 says, PW's statement is consistent.
And he might have thrown water to this, but he's not saying that they have broken open.
Kindly minute. I am one Rockaway threw water towards the ventilator of the bathroom. Accused and one Kishore pushed the door of the bathroom. That on breaking of the door, we found the body of the deceased has been burned and a plastic jar containing kerosene lying there. He was the cook valet. It is a fact that I have stated before the police I had purchased the kerosene and kept the same in a jar under the bed of the room. It is a fact that I have stated before the police that police came there. My lord, what I want to convey before your lordship is that this is
not at the relevant time.
No.
Cook at some
your lordship
point of time.
Your lordship can see.
In 1995.
I was a cook during 1995, but he was present. He was present in the house.
Present and he had brought the kerosene.
He had brought the kerosene.
Yes.
Malady, why am
Who kept he kept the kerosene under the bed?
Bad. Yes, that is what it is. Anyway.
Yes,
let him read.
Well, that I will come to later. I will address that point. Well, why I am conversing PW2 because PW2's statements say that I am one Rockaway threw water towards the ventilator of the bathroom. Means he was present, one Rockaway was present, along with the accused and BW1. There were 4 persons present in the house at that point of time. Further, the evidence shows that there were other persons who were also present. I will demonstrate, So, it is a fact on his statement. It can be presumed or it can be safely stated that he and one Rockaway threw water from the ventilator. Not breaking of the ventilator. That is correct,
Suppose somebody has stated something in the chief examination.
Substantive evidence.
That is the substantive evidence. And in the cross-examination, after being declared hostile, if he says that, yes, I have stated like this in 161 statement, that does not make it as a substantive evidence. Substantive evidence is something different. 161 CRPC statement is not a substantive evidence.
Absolutely.
Even if he stated the direction of the Supreme Court, if he states that after being stated nothing in the chief examination in the substantive evidence, if he stated that yes, I have made such a statement and also given that statement, that will not make that statement a substantive evidence. Just 161 re se eya kahithila. It's all right. So that a limited purpose, how you are to utilize the 161 statement. For what purpose the 161 CRPC statement is to be utilized. Now, if you see chief examination and his statement in this 161 CRPC statement, in the chief what he has stated, that ame dekhilu bathroom bitru dhua baharuthila.
Yes.
Ebong ame door ku broke open kolu ebong dekhilu je deceased sethi podi hei kerosene ପଢି ପଡିଥିଲା ଏହା ତ କହିଛି ଚିଫ ଏକ୍ସପେକ୍ଟେସନ ହେଲା ତେଣୁ ଏବଂ ଘଟଣା ପୂର୍ବରୁ ଆମେ ଆଙ୍କ ଦି ଜଣଙ୍କ ଭିତରେ ଝଗଡା ଦେଖିନୁ ଦିସ୍ ଇଜ ସବଷ୍ଟାଣ୍ଟିଭ ଏଇଟା ତାର 161 statement कौन थिला जे तांको सी ताकू गाली दउथला माने गणेश पूजा रे काहे की लेट रे उठिलु एटा होची से कथा एवं जो प्रथमे आगे जने सी निजे आ राम बाबू ए माने जो वाटर पकेले कोठी टुवर्ड्स वेंटिलेटर थ्रू रे पकेले तापरे सी आ जो किशोर आसिकिनी डोर ओपन कले so can you say that these two statements, what has been stated in court, what has been given in the 161, can they stand together?
But here I just want to bring to your lordship's strong consideration is that not only he, one Rathod was also present at this point. But here the prosecution has tried to make.
You are right that some evidence has coming that one Rathod Babu was present and prosecution has not examined.
Not
He
examined.
might have been examining, the statement might have been recorded, he might be a charge sheet witness, but the prosecution choose not to examine.
Not to examine.
So that's a different matter. So, but what evidence the prosecution has examined? So if those things establishes your
evidence, then I'm to be convicted.
really because a witness has not been examined.
I'm not on that matter. I want to canvass before your lordship that I want to just demonstrate before your lordship that the chain of prosecution based on circumstantial evidence is not made out. That I want to canvass before your lordship from the evidences. That
yes, Mr. Bose, one more thing can also be said. The part of evidence is forthcoming from PW2.
Yes.
With regard to the breaking open of the door, rather, finds supports from the cross-examination where he is reiterating that the door was broken.
Yes.
Whereas, with regard to the ventilator, it is not there in the substantive evidence first of all. And in this cross-examination, if at all he is saying about it, he is simply saying not breaking open.
No.
He is simply saying had thrown water towards the
ventilator.
So not towards the ventilator. Yes.
That I'll come later. I'll show with the evidence that how it contradicts from each other.
Right.
Then your lordship may kindly see the evidence of the child, that is PW3, at page 85. When he was put for cross-examination by the public prosecutor. Paragraph 3, last 3 lines. My mother used to rise late in the morning occasionally. It is not a fact that to such habit of late rising, my father used to abuse my mother. Then the next page. It is not a fact that I have stated before the police that my father used to pick up with my mother always due to late rising, and on the date of occurrence, accused has abused my mother because of late rising. That I went with PW1 people after seeing the quarrel. He had seen mother and father quarreling. That he
it is not a fact.
Your statement in the 313 statement, more free sang
Yes.
झगड़ा हुए नहीं.
Yes, he has not spoken.
से लाइट रे प्ली ही नहीं नाती. ଆଉ ଅନ୍ୟ କାହାର 161 କୁ ଦେଖିକି ଆପଣ ତ ନିଜେ ପଚାରିଲେ ଏଇ ୱିଟନେସ ର ଷ୍ଟେଟମେଣ୍ଟ ଯେତେବେଳେ କନଫ୍ରଣ୍ଟ ହେଇଛି ଆପଣଙ୍କର ଆନ୍ସର ନଥିଲା କି ଆମେ ସେଦିନ ଦେଖିଥିଲୁ ପୁରା ଯୋଉ 313 ଷ୍ଟେଟମେଣ୍ଟ.
Yes, you are not correct. ଆମ ଭିତରେ କିଛି
ଝଗଡ଼ା ନାହିଁ କିଛି ନାହିଁ.
But this
rather had the plea been taken that there was quarrel between the husband and wife, probably the court could have
that too,
taken an inference that such quarrel
resulted in the committal
this extent.
Yes.
Hmm.
The court did not get any.
Yes.
No.
I'll let me place other facts.
In view of your statement.
Yes.
And whatever is common record, the substantive evidence. Can we just take can we hold that there might have been some quarrel between the two, and that might have
resulted in losses.
ଆପଣଙ୍କର କେସ୍ ହିଁ ନୁହଁ, କୌଣସି ସାକ୍ଷୀ ମଧ୍ୟ କହୁନାହାନ୍ତି ଯେ ସେଦିନ ସକାଳେ ସବଷ୍ଟାଣ୍ଟିଭ ଏଭିଡେନ୍ସ। ତେଣୁ ହାଉ କୋର୍ଟ ତ ଆପଣ ଯାହା ଆଇଦର ପ୍ରସିକ୍ୟୁସନ କେସ୍ ଆଉ ଡିଫେନ୍ସ କେସ୍ ଆକୁ ଦେଖିକି କୋର୍ଟ ଇଏ କରିବ, ତେଣୁ ମାଇଟ୍ ହାଭ୍ କଲେ ମାନେ ଏଗୁଡାକ କୋର୍ଟ ଗୋଟେ ଥାର୍ଡ କେସ୍ କ୍ରିଏଟ କରିବ।
No, cannot. But your lordship may kindly see, I will take two other witnesses. My lord may kindly see PW7. That is at page 93.
Doctor,
Yes. My lord, he examined the appellant before your lordship. And he found two injuries.
is he appellant?
Yes.
Murthy. Right. Examine Murthy, right.
Yes. Abrasion on the dorsal aspect of the right middle finger in the proximal, 1/3 of size 1/4 inch into 1/6 inch. Abrasion on the dorsal aspect of the right ring finger in proximal, 1/3 of size into 1/6 inch into 1/6 inch. Both the injuries are simple in nature and could have been caused by hard and blunt object. Age of injuries within 48 hours from my date of examination. This was on the accused. Next paragraph to your lordship, may kindly say. On the same day at 5 p.m., I have examined Kishore Chandra Behra, son of Shekhar Behra, he is DW1. I have found the following injuries. Partial burning of hairs. Next page, my lord. Partial burning of hairs just above the forehead and on the left parietal region, which is simple in nature and could have been caused by fire. Range of injuries within 12 hours from the time of my examination. Now, DW1 had stated in the evidence that he tried to gush the fire by using a blanket. Your lordship had seen that portion. And there was burning of forehead stated. This has been fortified by the evidence of the doctor that there was burning of the hair above the forehead on the left parietal region. What is stated in evidence that he tried to use the fire by putting a blanket, and for that his hair was burnt, has been fortified by the evidence of this doctor that he had tried to extinguish the fire and that resulted in burning of the hair.
ଅନ୍ୟ କୌଣସି ୱିଟନେସ୍, ପ୍ରସିକ୍ୟୁସନ ୱିଟନେସ୍ ବା ଆପଣ ଯୋଉ ଆକ୍ୟୁଜ ଷ୍ଟେଟମେଣ୍ଟରେ କିଛି କହିଛନ୍ତି କି କିଶୋର ଥିଲା ବୋଲି ସେଠି ସେ ଏମିତି ଟ୍ରାଏ କଲା ସେଭ୍ କରିବାକୁ ଇଏ ଏସବୁ ଜିନିଷ ଯାହା ବି ହଉ ଯୋଉ ଆପଣଙ୍କର ଆପଣ ହିଁ ଉପସ୍ଥିତ ଥିଲେ ଘରେ,
4 ଜଣ ଉପସ୍ଥିତ ଥିଲେ।
ଆପଣଙ୍କର ଅପରଚ୍ୟୁନିଟି ଦିଆହେଲା ଆକ୍ୟୁଜ ଷ୍ଟେଟମେଣ୍ଟର ଉଦ୍ଦେଶ୍ୟଟା କଣ, ଯାହା ଯାହା ଆସିଲା ତାକୁ ଆପଣ ଏକ୍ସପ୍ଲେନ୍ ଇଟ୍ ଆଣ୍ଡ ଆପଣ ଯଦି କଣ କହିବାର ଅଛି ଲାଷ୍ଟ କ୍ୱେଶ୍ଚିନ୍ ଆପଣ କହିବେ। ଆପଣ ଯେତେବେଳେ ପଚରା ଗଲା ଯେ ଡାକ୍ତର ମାନେ ଆପଣଙ୍କୁ ଏଇଆ ଇଞ୍ଜୁରି ଦେଖିଲେ, ଆପଣ କହିଥାନ୍ତେ ଆଜ୍ଞା ହଁ ମୁଁ ସେ କବାଟ ଯେତେବେଳେ ଭାଙ୍ଗିବାକୁ ଚେଷ୍ଟା କଲି ସେତେବେଳେ ଏମିତି ଇଞ୍ଜୁରି ହେଇଥିଲା କି ଏଇ ପରିସ୍ଥିତି, ଆପଣ କିଛି କହିଲେନି, ଖାଲି କଣ କହିଲେ
these injuries are caused by the
for some other reason or something like that.
Yes. 38.
Who is the doctor?
313.
Who is the doctor denied?
338.
313 petition 38 para.
38 para.
ମିଛ କଥା
ମିଛ କଥା
No, message ଲେଖା ହେଇଛି. And the doctor's opinion is also there. There is no.
ନାଇଁ ସେଟା ପଢନ୍ତୁ
ପ୍ଲିଜ, କାରଣ କ୍ୱେଶ୍ଚିନ୍ ନମ୍ବର ଏ ଯୋଉ ଏଭିଡେନ୍ସ ଟା ପ୍ଲେସ୍ କରେନି PW7 ର ଏଭିଡେନ୍ସ କନଫ୍ରଣ୍ଟ ହେଇଛି ଆପଣଙ୍କୁ କ୍ୱେଶ୍ଚିନ୍ ନମ୍ବର 14 and 15 page 71 and 7 ସେଠି ଆପଣ ପଚରାଗଲା ଏଇଆ ଦେଖିଲେ, ଏ ଯଦି ଇଞ୍ଜୁରି ଦେଖିଲେ ସେଇଟା ପଚରାଗଲା, ପ୍ଲସ୍ ଏ ଯୋଉ କିଶୋର ମଧ୍ୟ ପଚରା ହେଇଛି 15 ନମ୍ବର କ୍ୱେଶ୍ଚିନ୍। 14 ନମ୍ବରଟା ହଉଛି ଆପଣଙ୍କ ନିଜ ଇଞ୍ଜୁରି ଏବଂ 15 ନମ୍ବରଟା ହଉଛି କିଶୋର। କିଛି ଖାଲି ହଁ ଟା ମାରିଦେଲେ
Question number 13.
Hmm.
It further transfers from the evidence of PwC that he had prepared. No.
14
Yes.
15
It transfers from the evidence of PW7, Dr. Pradipta Das, that on 29/8/95 on police requisition, he examined you and found one abrasion on the dorsal aspect, such and such. Both the injuries are similar, could have been caused by hard blunt object, or the identifier. He says yes. He says yes, it was there, injury was there. Then he says, it further transfers from the evidence of PW7 that we examined Kishore Chandra and found one partial burning of hair just above the forehead on left parietal region, which was simple in nature and could have been caused by fire. Age of the injuries within 12 hours from the of his examination. He said, what have you got to say? He said yes.
Oh.
He said yes.
ସେ ଇଞ୍ଜୁରି ଆପଣଙ୍କ ଦେହରେ କେମିତି ହେଲା?
ନାଇଁ ସେଟା ସାର୍ ଯୋଉ ଆର ଲୋକଟା ଥିଲା DW1 ତାର ଉପରେ ତାର ହେଇଥିଲା, ତାର ଜଳିଥିଲା, ଆକ୍ୟୁଜର ଜଳିନି।
ଆପଣଙ୍କୁ ଏ ପ୍ରଶ୍ନଟା ପଚରା ଯିବାର ଉଦ୍ଦେଶ୍ୟ କଣ? ଏଇଟା ଗୋଟେ ଆସିଲା ତ ଏଭିଡେନ୍ସ ଆସିଲା, ତେଣୁ ଆପଣଙ୍କୁ କନଫ୍ରଣ୍ଟ କରାଗଲା।
ସେ କହିଲା ହଁ,
ସେଠି କହିପାରିଥାନ୍ତେ ଯେ ହଁ ଥିଲା, ଏଇଥିପାଇଁ ହେଲା।
He has not provided an explanation, but he has said yes.
38
ନାଇଁ 38 କୁ ଆମେ ଯିବା। 38 ଟା କଣ ହଉଛି? ସେ PW11 କିଏ?
ଆୟୁ
ସାର୍ ସେଟା ମୁଁ actually PW when question number 15 sir, you have stated that yes, that there whatever injury was asked that PW forensic this injury, he stated yes. He may not have provided an explanation saying that yes, it was caused by extinguishing the fire, his hair was burnt, or there was some injury. He has not stated in detail, but he has said yes only.
And when he was examined by the doctor?
The accused?
Yes.
Accused was examined.
You see the timing.
After taken into custody.
Just see the timing.
No, before taken to custody.
No.
Just see the timing. He has
see the timing.
4:45. When the occurrence took place around 9:30. এই ଯୋଉ ଇଞ୍ଜୁରିଟା ଯୋଉ ହେଇଛି ବା ଇଏ ହେଇଛି ମାନେ ପ୍ରାୟ 6-7 ଘଣ୍ଟା ଭିତରେ ହେଇଛି। 48 hours ଆପଣଙ୍କର ଡିଫରେନ୍ସ ଆସିଯିବ। ଏଇ ଯୋଉ ଇଞ୍ଜୁରି ଯଦି ହେଇଥାନ୍ତା 6-7 ଘଣ୍ଟା ଭିତରେ ତାର ଅଛି ମାନେ ସେମାନଙ୍କୁ ଡିଟେକ୍ଟ କରି
କଲର ହେଇଯାଇଥାନ୍ତା, ଅଲଗା ସବୁ ଚେଞ୍ଜ ହେଇଥାନ୍ତା।
ତାର ବ୍ଲିଡିଂ ହବ, ଟିକେ ଶୁଖିଗଲେ ତାର କଲର ଚେଞ୍ଜ ହବ, ସେଥିରୁ ସେମାନେ ଡିଟେକ୍ଟ କରନ୍ତି। ମୋଦିର ଜୁରିସ୍ପ୍ରୁଡେନ୍ସ ଅଛି ଯେ ଗୋଟେ ଇଞ୍ଜୁରିଟା ହେଲେ ପ୍ରଥମେ କେମିତି ଦେଖାଯିବ, ନାଲ ଦେଖାଯିବ କାହିଁକି ନା ବ୍ଲଡ ବାହାରୁଛି, ତାପରେ କେମିତି ତାର ଚେଞ୍ଜ ହବ। 48 hours ଯୋଉ ଗ୍ୟାପ ଟା କହୁଛି ମାନେ ଟିକେ ମାନେ ଫ୍ରେଶ ଇଞ୍ଜୁରି ନୁହେଁ। ଫ୍ରେଶ ଇଞ୍ଜୁରି ଥିଲେ ଜଣା ପଡିଯିବ ଆପଣଙ୍କର ଗୋଟେ ଖଣ୍ଡିଆ ହେଲା, ଫ୍ରେଶ ଇଞ୍ଜୁରି ଆଉ 2 ଦିନର ପର ଇଞ୍ଜୁରି ଆପଣ
the color changes.
So that is why he stated that it cannot be correlated with first of all the incident itself. That is, and number 2, you have not stated that any attempt was made for which I received that injury. Rather, whatever you have stated to the IO, that's a different, that eczema itala kotha koile, that's a different matter. DW1 ro jota कहउचंती ଆପଣଙ୍କର ବା ଆଉ କାହାର ଏଭିଡେନ୍ସ ଅଛି ଯେ ସେ ଲୋକଟି ସେଦିନ ଥିଲା ଏବଂ ସିଏ ଏଇଆ କଲା, ସେ ଯାହା ବି କହୁ, that must be
either by direct evidence or through cross examination.
Yes, ଆପଣଙ୍କର ଟୋଟାଲ କେସ୍ ହିଁ
that is not a case.
ପ୍ରୋସିକ୍ୟୁସନ କେସ୍ ର କାହାକୁ ସଜେଷ୍ଟ କରୁନାହାନ୍ତି, ସେ ଭଳିଆ କାହାକୁ ନିଜେ ବି ପ୍ଲି ନେଇନାହାନ୍ତି। ହଠାତ୍ ଗୋଟେ ୱିଟନେସ କୁ ଆଣି ଠିଆ କରେଇଦେଲେ ଡିଫେନ୍ସ ରେ, ଯିଏ କହିଲା ଏଇ ଯୋଉ କଥା ଏଇ ଭଙ୍ଗା ହେଲା ଇଏ ତ କହିଛି।
Let me go to one extent. I have not provided any explanation. I have not answered any question in 313.
No, you are supposed to, Mr.
Yes, I have not answered.
It is not a case of eyewitness. It's a case based on
circumstantial
evidence. And if the circumstances goes against you, you are to explain it. And you are present. 106 says
I was present in the house.
Explain କରିବାକୁ ପଡିବ। ଯଦି explain ନ କରିବେ then inference would be drawn against you.
But so also at the same time I would also pray before your lordships that the prosecution has to establish also the same.
That is the
That nobody doubts that.
See,
Why not?
let it be a simple case of an accused.
Yes.
We can also assume that the accused has an inherent right to tell lie. That is how we do not administer oath in 313.
Yes.
So he has inherent right to tell lie.
Yes.
But your position as an accused in the given set of facts is completely different, where 106 coming into play, you being not only a person present in the scene of occurrence, but also you are the husband. So, non-explanation of any of the incriminating material against you is volume in inference.
Yes, sir. Now I want to demonstrate before your lordship that the reliance on PW8, which is the scientific examination, which is the basis of my conviction, is to be discarded by your lordship in correlation with other witnesses. That I want to demonstrate, madam. I just demonstrated PW7 only to show that the fact that BW1 had stated that there was burning of hair, that I wanted to just apprise your lordship. Now your lordship may kindly see PW8, who is the star witness on whose basis I have been. Basically, the conviction has revolved around PW8.
So who is not that Mr. Author to whom PW2 has referred to?
No.
He is different.
He is
a scientific officer.
scientific officer.
Right. He is scientific officer.
My lord will see is at page 95.
Right.
One white color jerrycan was found near the wash machine in complete burnt the condition except lower part containing some kerosene.
A third, fourth,
Page 95.
two.
Page 95, last two lines. One white color jerrycan was found near the wash machine in complete burnt the condition except lower part containing some kerosene. One iron bucket, one plastic mug were found near the leg region of the deceased. Broken bangles were found in scattered condition in the bathroom. My lord may mark three things. First, he says that the jerrycan was completely burnt, which was near the washing machine, except lower part containing some kerosene. One iron bucket, one plastic mug were found. Means from his evidence, it can be stated that the plastic mug was not burnt and the iron bucket was in the position intact. This is his. And he, in his observation, stated no mark of violence detected in the door frame that your lordship has seen. I'll just state two other points. Paragraph number 4 and paragraph number 9.
No, ये जो आपण पढ़िले एथुरु कोन जणा पड़ुची जेतल डिसीज जेतेबेले जळुथिला she had come in contact with that jerrycan. She had not come in contact with iron bucket or plastic mug. जणे जेतेबेले जळी जाउची से जदी निजुकु सेव करिया को चाहिबो ताले प्रथमे आगे कोन धरिबो बकेट रे पानी कलेक्शन करिबो पानी मगरे पडिबो तनु सेईटा को आगे कांटेक्ट रे आसीबो ना जेरिकेन रो कांटेक्ट रे आसीबो
सब में एटी काहे देखौछि कि एटा संगरे मु PW10 और 11 रे देखिबो सर that the scientific examination was not done properly. That I will demonstrate. That's why I'm going before the lordship to see this once. Thereafter, I will take to PW10. Your lordship will see paragraph 4 at page 96 and paragraph 9 at page 96. The articles of the bathroom were found intact and undisturbed, though iron bucket and plastic mug were very close to the left region of the leg. This is his observation. And 9 says the color paint of the bathroom door outside was swollen and bulged, but inside part of the door was less effective to heat than outside. He wants to say that the door was never locked because he says that it was not tampered, bolts were not broken. His observation is that the door was never locked. The door's outer portion was more swollen and inner portion which was attached to the wall of the bathroom was not disturbed. This is his claim. Then your lordship may kindly see at the same time PW page 103.
এই ଯୋଉ ଡୋର ଟା
ଆଜ୍ଞା
ମୋଷ୍ଟ ଲାଇକଲି ଏ ଡୋର ଟା ଭିତରକୁ ଖୋଲୁଛି
ଭିତରକୁ ଖୋଲୁଛି
ବାହାରକୁ ଖୋଲୁଛି
ନା ସାର୍ ଭିତରକୁ ଖୋଲିଲେ କଣ ହବ କି ଯଦି ନିଆଁଟା ଲାଗିଲା এই ସାମ୍ନା ପର୍ସନ ଟା ସାର୍ ଜଳିଯିବ
outer side
ଆଉଟର ସାଇଡ
ଆଉଟର ସାଇଡ ଜଳିବ ସେଇପାଇଁ
ଜଳିନି ବୋଲି ସେ କହୁଛନ୍ତି
ରାଇଟ ଭିତର ସାଇଡ ଟା obviously
ଦେୱାଲକୁ ଲାଗୁଥିଲା ସାର୍ ଭିତର ସାଇଡରେ ନିଆଁର ଧାସଟା ବାଜିନା
means it is consistent with the opinion of the scientific officer that the door was not closed.
not
It was
this is the observation of the scientific
exactly.
officer
Exactly.
sir I will not demonstrate
with this report, because outer side is found to be pin.
sir I will now try to convince your lordship that both the sides of the door were
Let's
bulged. Sir, that your lordship can see. Your lordship may kindly come to PW11. PW11, my lord may kindly see the last 4 lines at page 111. Furthermore, the paint on both the sides of the bathroom was swollen and was bulging out at many places, which showed that the heat had affected both sides of the door.
Yeah. Scientific report doesn't say no.
No, sir, scientific
report says
yes.
that the inside was less effective. See,
पूरा मना करना
पूरा मना कर
सर से किंतु एक आइए जे फर्स्ट देखिले जे फर्स्ट जाके विजिट कला तापर साइंटिफिक वाला को देखिले से कहउचंती furthermore the paint on both the sides of the bathroom was swollen and was bulging out in many places.
Yes.
Both sides of the bulging. Which showed that the heat had affected both sides of the door.
Yes.
Sir, my humble submission before your lordship is that when the scientific examination person went, he only stated,
ସେଇଦିନ
sir, କାହିଁକି ତାଙ୍କର ମୁଁ statement ଦେଖିଲି sir, ସିଏ କହୁଛନ୍ତି ମୁଁ ଆଗେ ଦେଖିଲା ପରେ ମୁଁ scientific examination କୁ ଡାକିକି ସାଙ୍ଗେ ଦେଖିଲି. Sir, how come scientific examination could not find the bulging of the door outside, inside and outside?
No. That also so, but not to the extent it is in the outer side.
Sir, but
Less effective.
but it says it is consistent.
Who is saying consistent? No, in some places. In some places.
And furthermore, the paint on both sides of the bathroom was swollen and was bulging out at many places.
So that is how the scientific team report has to be given more primacy than the naked eye of the IO.
So naked eye of the IO says
right.
that both sides.
Yes, that is also.
But scientific examination says
जो ये परी देखंदी जो
मैग्नीफाइंग ग्लास
देखंदी ସେମାନେ ବହୁତ ଭେରିଫାଇ ସାଇଣ୍ଟିଫିକ ଅଫିସର ମେ ସମଟାଇମ୍ସ ମିସ୍ ସମଥିଙ୍ଗ ଆମକୁ ପ୍ଲେନ ରେ ଯୋଉ ଜିନିଷଟା ଜଣା ପଡିବନି ଗୋଟେ ମ୍ୟାଗ୍ନିଫାଇଂ ଗ୍ଲାସ ଦେଲେ ଆପଣଙ୍କୁ ବେଟର ଇଏ ଜଲା ଆସିବନି ଭ୍ୟୁ
but he should have seen it in a more better way and the scientific examination should have seen it in a more better way.
तो ठीक देखिए
मना कर
नहीं सर से जो कहले जे भीतर साइड टा कम जळिछि आ बाहर साइड टा बेसी जळिछि आइयो कहउछंती जे बोथ साइड रे सेम ऑलमोस्ट सेम.
आगे गोटे कथा क्लियर ही जानतु जदी डोर टा बाहर को खोलु थांता एवं बाथरूम भितरे एमाने पसिकिनी घटनाटा करी थांते ताले हुए तो डोर टा टोटली अफेक्टेड ही नहीं न राइट क्लियर और बाहर रहियो से मे बी डोर टा जेतु भितर को खोलुची तेणु जदी जणे माने हां सुइसाइड कले कोन हबो ना डोर टा जदी बंद करी जणे सुइसाइड करिवो ताले भितर पोर्शन टा बेसी
एग्जैक्टली
हला कारण ताकू तापरे से माने आसीबे बाहर पटु खोलिबे से पर्यंत ए भीतर पटटा बहुत डैमेज है हला ଭିତର ପୋର୍ସନ ଏ ଯୋଉ ସେ ବାହାର ପଟଟା ଡୋର ହେଲା ବହୁତ କମ ଇଏ ହବ କିନ୍ତୁ ଆର ଜଷ୍ଟ ରିଭର୍ସ ହେଇଛି ମାନେ
ବାହାର ପୋଷ୍ଟଟା ବେଶୀ ଜଳିଛି ଭିତରଟା କମ
ଏଇ ଯେ ବାହାର ପଟଟା ଏମିତି ଆସିକିନି କାନ୍ଥ କଡକୁ ରହିଛି ହେଲା ତେଣୁ ସେଇଟା ଇଏ ହେଇଛି ବାକି ଯୋଉ କମ ଇଏ ରହିଛି ଯୋଉଟା କାନ୍ଥ କଡକୁ ରହିଯାଇଥିଲା ଭିତର ପଟୁ ଡୋରଟା ଖୋଲିକିନି ସେଇଟା କମ ଆଫେକ୍ଟେଡ ହେଇଛି ସେ ସେଇଆ ହିଁ ଦେଖୁଛନ୍ତି
ସାଇଣ୍ଟିଫିକ ଏକ୍ସାମିନେସନ ସେ ସବୁ ଦେଖିଲେ କିନ୍ତୁ ୟାକୁ କହିବା କଥା ହଉଛି that paint on both the sides of the bathroom was swollen and was bulging out in many places.
But it is not that a matter which is contradictory.
No,
Both are saying
sir,
somebody is giving eating more intensity to it. Yes, the other.
Sir, I say only subject to yes, subject to correction by your lordship that the complete conviction basing on PW8 that yes, the accused has killed the deceased.
No.
It
There
cannot be
other circumstances.
cannot be accepted because the pattern of the shoot of the bucket was found lying very close to the feet of it was uniform, indicating that the deceased had not disturbed it. But if you lordship may kindly see at the top, third line from the top, the inner bolt of the bathroom was not tampered, nor there was any mark of violence. This is correlating with scientific examination. The inner bolt of the bathroom was found in open condition. The pattern of shoe deposit on the panel of the bathroom frame of the bathroom door was uniform and undisturbed. The pattern of shoe deposit on the inner bolt of the bathroom door indicated that it was not disturbed. The broken glass pieces of the window of the bathroom were found near the dead body of the deceased. I did not mark any injuries on the forehead, palm and back of the deceased, which was in contact with broken glass pieces. I also noticed few bangles of the deceased scattered in the bathroom and other bangles were intact in the wrist of the deceased. There was no mark of injury on the wrist of the deceased. I further noticed that the pattern of smoke deposit on the walls and other articles of the bathroom were uniform. There was no mark of violence, resistance on the walls, though the bathroom size is to be small. The matchbox containing few live matches were found in the spot which was not affected by fire. However, plastic jerrycan found in the spot was completely been melted. It is correlating with the scientific examination.
So one thing is not understood when a victim is going to be burnt.
Yes.
And not that she maintained a stoic silence, keeping herself close to the bathroom, clicking it from inside, but having raised hulla, saying Marigali, means there is an anxiety on the part of the victim to come out of the situation.
Absolutely.
If that is so, how then the other articles remain the same? The door didn't open and she has the anxiety to come out. If she has not shouted and simply she got herself immolated and died inside, nobody could know the body got charred. One story. Once the other story that she raised scream, Marigali, ତାପରେ ବି ସବୁ ଜିନିଷ ଯେମିତିକୁ ସେମିତି ଅଛି, ଡୋର ଖୋଲା ଅଛି. This is what is.
The smoke or uniform.
Yes. Sir, to answer that, yes. My lord asked me a very pertinent question.
ଏଇ ଯୋଉଟା ଆପଣଙ୍କୁ ଏକ୍ସପ୍ଲେନ କରିବାକୁ ପଡୁଛି ଆମେ ସେଦିନ 5 ନମ୍ବରଟା ଆମେ ଯୋଉ ଧରିଥିଲୁ ସେଦିନ ଯେ broken pieces of glass of ventilator of the bathroom were detected beneath the bed.
Yes, sir, I will explain that. But your lordship,
କେସଟା ଯଦି ହଉଛି ଯୋଉ ଆମେ ସେଦିନ ପଚାରିଥିଲୁ ଆପଣଙ୍କୁ ଯଦି ବାହାରୁ କିଏ ଭାଙ୍ଗିକିନି ସେଇପଟେ ଆଇଦର ଭିତରକୁ ଆସିବାକୁ ଚେଷ୍ଟା କରିବ ବା ପାଣି ପକେଇବାକୁ ଚେଷ୍ଟା କରିବ ତାହେଲେ ସେ କାଚ ଗୁଡାକ ଚାରିଆଡେ ସ୍କାଟର୍ଡ ମ୍ୟାନର ହେଇକି ପଡିଥାନ୍ତା.
ସାର୍ ମୁଁ ଆପଣଙ୍କୁ ସେଟା କହିବି. ସାର୍ ଟିକେ ଆପଣ ସେ କ୍ରସ୍ ଏକ୍ସାମିନେସନ ଅଫ ଦି ସାଇଣ୍ଟିଫିକ ଏକ୍ସପର୍ଟଟା ଦେଖନ୍ତୁ ଯୋଉଟା ଆପଣ ମାଇକ୍ରୋସ୍କୋପ ରେ କହିଲେ. ସାର୍
PW8.
ସାର୍ ଟିକେ paragraph 4 ଲାଷ୍ଟ 4 ଲାଇନ ଦେଖିବ ସାର୍. I have not collected any material from the bathroom for laboratory test. I have not tested any material of the bathroom scientifically on the spot. My report is based on visual appreciation without any microscopic test. He saw, why I want to convince your lordship on the point, that he saw with his naked eyes that the bathroom was swollen and burst, but inside part was less effective to heat than outside.
Yes.
But the IO stated both the sides were burst and the heat had affected both the sides of the door. Sir, he has not taken the trouble of making a microscopic investigation. He has just seen in his visual appreciation. Then, my lord may kindly see the PW9. One question last occasion when I was addressing my lord stated one thing to me, that if a person, no carbon is there, then the presumption is that a dead body was burnt, not a live body, because there was nothing found in his blood. Now your lordship may kindly see PW9 at page 99. On dissection, I found the following. Shooting and blood lingered mucus present on trachea. My lord, this word shooty is the particles which flow on the air due to a fire. If you burn paper or cloth, the shoots are thrown outside. It was found on the trachea. So, my humble submission was, before your lordship, that a dead body was not burnt. She was alive and that was found inside her trachea. She was not previously, I want to convince your lordship that she was not murdered and the dead body was brought to the bathroom and it was burnt.
No, there might be something जो last time we allowed उसे वंचित
condition କରିଥିଲେ ସେ ଅବସ୍ଥାରେ ତାକୁ ମନେକର ତାର କିଛି କରିବାର ନାହିଁ.
Sir, more କହିବା ଆପଣ to before your lordship is that the dead body was not burnt. It is not that he was killed previously and the dead body was burnt by the accused. That I want to just justify in this word. That she was alive when this, merely because a blood report doesn't make out a carbon methylation in the blood, will not justify the prosecution that the murder was committed and the dead body was burnt to remove the evidences of this death. This was that. Then your lordship will see, I have opined that injuries were antenatal in nature. That your lordship will see at the IO made following queries on 1995. Paragraph 4. My answer was that the mode of death was asphyxia and the time since death was 4 to 12 hours as mentioned in my report. Exhibit 10 is the said query report of IO and Exhibit 10/1 is my answer and Exhibit 10/2 is my signature on my answer report. The IO made further query on 4/9/95 as follows. To ascertain if asphyxia was due to throttling, stroke strangulation or suffocation arising out of the smoke produced by burning. To ascertain if the cause of death was suicidal or stroke homicidal or accidental. I am giving a reply that the mode of death was asphyxia, shock and shock, but due to suffocation resulting from inhalation of smoke from combustion. The manner of the death was not accidental. However, my findings were not conclusive to opine whether the death was homicidal or suicidal in nature. But by this evidence, I want to canvass before your lordship that the deceased was not killed prior to burning. There was a burning. Technically burning. Now your lordship has to see whether I have justified my stand under 313 or had come and justified and as per 106 of the Evidence Act as my lord has rightly. That discussion your lordship will make. But my humble submission before your lordship is that there was no prior death. the date that the prosecution, which the learned trial court has proceeded on the notion that there must have been killed and I will be convicted under 302, that date was not prior. Because if your lordship sees the consistent evidence of the independent witnesses, they said that they heard a halla, Morigali. The husband says, Podigali. I will just demonstrate from other evidences also that from the spot map and the evidences of other persons who had made the inquiry, there was no other bathroom in the MLA quarter. If your lordships kindly take the spot map.
Strangely.
No, there was nothing. Your lordship is saying. From the spot map, there were 2 latrines were shown and 1 bathroom. And there was no attached bathroom in an MLA quarter of this type in this area. But there may be, there other MLA quarters may have a 2 bathroom or a attached bathroom or having 2 common bathroom. That is a different aspect. But this type of house did not have any other, because the IO and the other independent police witnesses, they said that we have not seen any other. They have not given a concrete finding that there was any other bathroom attached to the MLA's personal room. That was not there. So there was only 1 bathroom. So the prosecution case, which created doubt in the mind of the court that yes, why did she come to this bathroom? If there was other bathroom, she could have used that bathroom. Why she came to a bathroom where the constituent people were using? My humble submission before your lordship would be, the prosecution has not made out a case that there was separate bathroom. Rather, the spot map and the evidences of some persons, they are silent whether there are other bathroom or not. Rather, they say that the MLA was sitting in the room of the MLA. There was 2 other intervening rooms, which directly cannot see the bathroom. There were 2 other intervening rooms. Thereafter, the bathroom was there. So the bathroom was quite a distance from the personal room of the concerned MLA. PW10 has stated, my lord. And moreover, my lord, PW.
Yes.
My lord, PW6, the SI of Kharbalnagar police, who was examined as PW6, in his cross-examination, I do not remember as to when I read it. I cannot say the total number of bedrooms and bathroom in the Sword quarter. But one is he is also one part of the investigating team, and there is admittedly a death case, or if let us hold that it's a case of murder. But when they are seeing that the body was found in the bathroom, they should have made inquiry that yes, there is any other bathroom or not. There is any other room where the murder had, so-called murder had been committed. They did not say anything. They did not even take the trouble of counting the rooms and bathrooms. And the spot map, if your lordship may kindly see, the spot map also doesn't make out a case of another bathroom attached to the personal room of the MLA. Of course, I cannot, before your lordship, I cannot give my personal opinion of my visit to such a thing. That is, of course, off the record, I cannot say. But I have verified from my sources that this type of MLA quarters did not have any other bathroom. Of course, that is my personal experience, which is nothing on the record. Then, my lord, may kindly see. Spot meta amor research. It am out to bahari. It is data lecture. Bathroom. এই দুটা স্টোর ডাইনিং তারপরে কিচেন এটা স্টোর রুম তারপরে হ্যাঁ সে কন্ডিশন হ্যাঁ সেটা পড়িবা সেটা।
Yes.
My lord, I would again humbly pray before your lordship to see the evidence of PW10.
Is the proximate age of the victim mentioned anywhere? No.
That very reflected in the PM report.
No, it's not there. I was going to. It's not there. Normally it is there. It's
There.
nahi it. ଇଏରେ ଥାଇପାରେ ଇନକ୍ୱେଷ୍ଟ ନାଇଁ
स्पॉट मैप पे जहाँ देखी
Madam.
बेडरूम ऑफ द इनफॉर्मेट माने जी एक्यूज
Yes.
ସେଠି କିଛି ମାନେ ଇଏ ନାହିଁ ତାକୁ ଆଟାଚ ବାଥରୁମ କିଛି ନାହିଁ
ନାହିଁ।
ମଗର ସେ ପେପର ବୁକ୍ ର ଯୋଉ ଇଏଟା ରହିଛି
Yes, ma'am. Page 123.
ମାନେ ଏଇଟା ୟାର ହଉଛି DS 18/1 18/1 ଟା ହଉଛି ସ୍ପଟ ଅଫ କ୍ୱାର୍ଟର ଅଫ ଦ ଇନଫର୍ମ ତାକୁ ଏଇଟା ଏନଲାର୍ଜ କରି ଦେଖେଇଛି ଏଇଟା ହଉଛି ଗେଷ୍ଟ ରୁମ୍ 1 ଗେଷ୍ଟ ରୁମ୍ 2 ବାରଣ୍ଡାଟା ସାମ୍ନାରେ ଯାଇଛି entrance baranda
এটা বারান্দা
baranda ଲେଖିନି bench
এটা বেঞ্চ পଡିଛି এটা ବାରାন্দା ଲମ୍ବା
ଏଇଟା
ବାରାନ୍ଦା
ହଉଛି ଦେଖିଛି ବେଡରୁମ ଅଫ ଦି ଇନଫର୍ମାଲ ଏଇପଟେ
ହେଇଯାଇଛି
ଲାଟ୍ରିନ୍
property।
ଦିଟା
ଦିଟା ଅଛି ଦୂରକୁ ଅଛି
ଦୂରକୁ ଅଛି ମାନେ ତାମାନେ ସେ ଯିବାକୁ ପଡିବ
ହୁଁ।
ଗେଷ୍ଟ ରୁମ ଦେଇକିନି ଏପଟେ ଆସିକିନି
এটা ଗୋଟେ ବାହାର ଜାଗା ତାପରେ
ନାଇଁ ବାହାର ମାନେ with
Out-
all
outside the quarter.
ଭିତରେ ହଁ
She was born outside of the quarter, but
ହଁ ଦ୍ୟାଟ ଇଜ ବଡ
ସେଇଟା ପୁରା ଅଛି
ଏଇଟା ଏଇଟା
ଆପଣ ଦେଖୁନାହାନ୍ତି ସେ ସ୍ପଟ ନାଇଁ କି
ସ୍ପଟ ରେ ସେଇଟା ଅଛି ବାହାରକୁ ଅଛି
ବାହାର-
ଆଟାଚ ତାମାନେ ନାହିଁ ଦିଟା ଯାକ ଯୋଉଟା ଅଛି ବାହାରେ ଅଛି
ଦିଟାକ ଯୋଉ ଅଛି ଗୋଟେ ବାଟ ଦେଇକିନି ଗେଷ୍ଟ ରୁମ 2 ଦେଇକିନି ଆଉ ପଶିବ ତାପରେ ସେ ବାଟରୁ ବାହାରିବ ଏଟା ବାହାର ବାଟ ତାପରେ ବାହାର ଦିଟା ଲାଟିନ୍ ଅଛି ଆଉ ସେଠିକି ଲାଗିକି ଷ୍ଟୋର ରୁମ ଅଛି ସେଇ ଯୋଉ
ହୁଁ
ମାନେ ଷ୍ଟୋର ରୁମ୍ ଡାଇନିଂ ରୁମ୍ ଲାଗିକି ତାପରେ କିଚେନ ଆଉ ଗୋଟେ ସେଠି ଷ୍ଟୋର ରୁମ୍ ଅଛି ତାପରେ ସେ ରୁମ୍
ଏଟା ସେୟାର
ସେଟା
ଏଟା ସେୟାର
ଛୋଟ ବେଡରୁମ କୁ ଲାଗି ଗୋଟେ ଛୋଟ ଷ୍ଟୋର ରୁମ
ଷ୍ଟୋର ରୁମ୍ ଅଛି ତା ସାଇଡରେ ତ କିଚେନ
ଅଛି ରାଇଟ୍
ତା ସାଇଡରେ ଡାଇନିଂ ରୁମ୍ ସାର୍ ତା ସାଇଡରେ
ଏଟା ବି ଆଉଟସାଇଡ
ସାର୍ ଗେଷ୍ଟ ରୁମ୍ 2 ରୁ ଗୋଟେ ବାଟ ଖୋଲିଛି ୱେରେ ଯୋଉଟା କି ଷ୍ଟୋର ରୁମ୍ ଆଡକୁ ବି ଯାଉଛି ଗୋଟେ ଦିଟା ଲାଟ୍ରିନ୍ ଆଉ ବାଥରୁମ ଟା ସାଇଡରେ ସାର୍
ନାଇଁ ସୋ ଏଇଥିରୁ ଜଣା ପଡୁଛି ଯାହା ସ୍ପଟ ମ୍ୟାପ କୁ ଯେ ମାନେ ବେଡରୁମ କୁ ଲାଗି କୌଣସି
Bathroom ନାହିଁ।
ବାଥ ରୁମ ଲାଟ୍ରିନ୍ ନଥିଲା ତେଣୁ ଯିଏ ବି ୟୁଜ କରିବ ଏଇ ଦିଟା
ଏ ଦିଟା
ଲାଟ୍ରିନ୍
ଭିତରେ।
ୟୁଜ କରିବ
ତା ଭିତରୁ ଗୋଟେ ସେ କହୁଛନ୍ତି ଯୋଉଟା କନଷ୍ଟିଚୁଏନ୍ସି ବାଲା କରନ୍ତି ଗୋଟେ ସେମାନେ କରନ୍ତି
ମାନେ ମାନେ there are two latrines
ହଁ there are
ହଁ
two.
two
There,
latrines
it is there
yes
no the one doubt was there
yes
that is why it is now
Yes.
clear
my lord questions made me tried help me to do little more
always it is there provided it is taken that way
no my lord
none of our question is to give a conclusion to it but
we are
to embolden
we have to learn every day
arrive at truth
yes
ଆପଣ ବି ପଢୁଛନ୍ତି ଆମେ ବି ପଢୁଛୁ ତେଣୁ ଯେତେ ତାକୁ ମାଇନ୍ୟୁଟଲି ଷ୍ଟଡି କରିବ ସେ ଜିନିଷଟା ସେତେ କ୍ଲିୟର ହବ
yes madam
ତେଣୁ କୌଣସି କ୍ୱେଶ୍ଚିନ୍ ପୋଜ କଲା ମାନେ ଇଏ ମାନେ one should not a lawyer's duty should not take
no, absolutely madam
adverse view or something like that.
my lord that unless that process of churning comes the truth cannot come out
ତେଣୁ particularly ଏଇ ଯୋଉ
yes
circumstantial evidences ଗୁଡା ବେଶୀ ଦରକାର ଏଟା ତ ଡାଇରେକ୍ଟ ଏଭିଡେନ୍ସ ଥିବ ଏଇ କହିଲା ଭାଙ୍ଗିଲାନି ଜେରାରେ ଗଲା ସେ କାମ ସରିଲା ଏଇଗୁଡାକରେ ଟିକେ ଆଉ ଏଇଗୁଡାକରେ ଦରକାର circumstantial evidence ପୁଣି ଗୋଟେ ଘର ଭିତରେ ହେଇଛି
yes
ସେଇଟା ଆହୁରି
Yes.
କାରଣ ବାହାରେ circumstantial evidence
many interference yes
that's a
lot of interference could be there intervention could be there and the time since when this taken is so close
this case is different from other circumstances outside
yes yes yes
ମାନେ ଆପଣଙ୍କର ଏଫଆଇଆର ରେ ହିଁ ସେ ଯୋଉ କହୁଛି ଫାଷ୍ଟ ଲାଇନ ଟା
ଆଜ୍ଞା
ଯେ ଇନର ବୋଲ୍ଟ ୱାଜ ନାଇଦର ଟେମ୍ପର୍ଡ
yes
ମାନେ ତାର ଯୋଉ ଭିତର ଜିନିଷଟା ଏବଂ ନର ଏନି ଭାଉଲେନ୍ସ ମାର୍କ ୱାଜ ନୋଟିସ୍ଡ ଅନ୍ ଦି ଡୋର
yes
that is one thing which goes against that plea that ଆପଣ ମାନେ ଯାଇ ଜବରଦସ୍ତି ମାନେ
Push କଲେ ତାପରେ
କରିକିନି ତାକୁ ଖୋଲିକିନି
ଥରେ ସେ କଲା ପାରିଲାନି ତାପରେ ଆଉ ଜଣେ ଫେର
ଆଉ ଜଣେ
ଆସିଲା
ଆସିଲା ସେ ପ୍ରଥମ କହୁଛି
Yes.
ଆମେ କଲୁ ତାପରେ ଦି ଜଣ ଆସିକିନି
so what is the
ଫୋର୍ସଫୁଲି ସେ ଦି ଜଣ ହେଲେ କିଛି ଭାଉଲେନ୍ସ
ହବ ତ?
କିଛି mark ଟା ରହିବ
ଯୋଉଟା କି ଟୋଟାଲ ନାହିଁ ଦ୍ୟାଟ ଇଜ ଅଲସୋ ଦି ସାଇଣ୍ଟିଫିକ ଅଫିସର
yes
ଇଏ ଏଫଆଇଆର ରେ ଯାହା ଲେଖିଛି ସେ
well that is not in dispute that is not in dispute I am not on that but my lord merely if one circumstances is against me that cannot entitle me
no solitary circumstance will not be there.
but I will demonstrate from PW10 if your lordship permits I will place that subject to after your lordship verifies the record I will place PW10 again
ସେଇଥିପାଇଁ ଦେଖୁଛି ସେ ଯୋଉ ପାରା 1 ଟାରେ ଏଫଆଇଆର ରେ
ଆଜ୍ଞା
ଯଦିଓ କମ୍ପ୍ଲେନାଣ୍ଟ ଏବଂ ଅନ୍ୟ ୱିଟନେସ୍ ମାନେ କାଟେଗୋରିକାଲି କହିଲେ ଯେ ଦି ଡୋର ୱାଜ ବ୍ରୋକ ଓପନ କିନ୍ତୁ ମୁଁ କୌଣସି ଭାଉଲେନ୍ସ ମାର୍କ
Calling, yes.
ପାଇଲି ନାହିଁ
Yes.
ବା ବାଥରୁମ ର ଡୋର କୁ ମୁଁ ଦେଖିଲିନି ଇନର ବୋର୍ଡ ଟା କୌଣସି
Yes.
ଯୋଉଟା କି ଆମେ ନର୍ମାଲି ଏକ୍ସପେକ୍ଟ କରୁ
yes
ଗୋଟେ ରୁମ ଟା ଯଦି ଭିତରୁ ବନ୍ଦ ତାକୁ ଫୋର୍ସ ଅପନ୍ କଲେ
କିଛି damage ହବ sir.
So reasonability and normal prudence has to be taken, no?
মানে some damage is to be there. I cannot say that no. এটা ଏମିତି ନୁହଁ ଯେ କାଗଜ ସିଟ୍ କାଢି ନାହିଁ ଖାଲି ବେଲି ଖୋଲିଗଲା. No.
ତାହେଲେ ତ ସେ ପଳେଇ ଆସିଥାନ୍ତା.
Yes.
If that was the anxiety.
That was the anxiety. My lord, if the lordship sees EW10, who was the first person to enter and see it, paragraph 3 subject to if your lordship kindly see at page 103.
There is no semblance of this blanket. No, there is no semblance
That
of
has not ceased.
That was not seized.
ଏଟା ପକେଇକିନି ଯଦି ତାକୁ ନିଆଁ ଲିଭିବାକୁ ଚେଷ୍ଟା କଲେ ବ୍ଲାଙ୍କେଟ ଟା ତ ସେଇ ୟା ଭିତରେ ପଡିଥାନ୍ତା ନା
Bathroom.
ବାଥରୁମ ରେ ପଡିଥାନ୍ତା
କେହି ଆଜ୍ଞା କହିବି ନାହାନ୍ତି କି ସିଜ୍ ବି ହେଇନି.
ନାଇଁ କହିଛନ୍ତି ନା
ନା.
DW1 ଟା
ମୋର କହିବା କଥା ସାର୍
ମୁଁ କହିଲି that
ଦେଖିନି ସେଟା.
that is how what that is how far the
Defense story is
defense
believable.
story believable.
Yes. My lord, if your lordship may kindly see page 103 for a moment. And if your lordship permits,
Of
can I
course,
say
we can't
that?
stretch- we can't stretch it on ourselves,
Yes.
but then what is the acquaintance of the defense witness in the house of the accused that he could know where the blanket is there? Immediately he rushed and got the blanket and
My lord, he was staying there. This
no, but not in the bedroom.
DW1
Step right.
was staying
Of
there.
course, it is nothing is there. Where from he got it? He got a blanket.
Yes.
Where from he got that? It might have been his own.
Maybe, my lord. He was staying there. His evidence that I was
There.
staying there
There.
in the MLA quarters.
So this DW1 story that she put a blanket on the body of the deceased and obviously tried to extinguish the fire. So that is not found corroboration from either any prosecution
Yes.
witnesses or the IO who
Yes.
visited the spot, even the scientific official. ତାପରେ ସେ ବ୍ଲାଙ୍କେଟ ଆପଣ କହିପାରିବେନି ଯେ ତାକୁ ସେଠି ଇଏ କଲା ପରେ ତାକୁ ନେଇ ଘରେ ସାଇଜ କରି ଅର୍ଡିନାରୀ ସେଇଠି ପଡିଥାନ୍ତା
କିଛି ଆଜ୍ଞା ନିଆଁ ଯେତେବେଳେ ଜଳୁଛି ଏନି ସ୍ମୋକ or anything, there will be some burning, man.
ତାର
Cannot be, it cannot be used again.
ତା ଦେହରେ ପୋଡା ଦାଗ ଥାନ୍ତା
ଆଜ୍ଞା।
ତେଣୁ ଏଇ ଯୋଉ ଷ୍ଟୋରିଟା ଇଏ ଫାର୍ଷ୍ଟ ଟାଇମ ଗୋଟେ ଇଣ୍ଟ୍ରୋଡ୍ୟୁସ କଲା ଭଳିଆ ଲାଗୁଛି ଯେ ମୁଁ ତାକୁ ଯାଇକିନି ବ୍ଲାଙ୍କେଟ୍ particularly when ଆପଣଙ୍କର ସେ ପ୍ଲି ନାହିଁ କୌଣସି ସାକ୍ଷୀଙ୍କ ପ୍ଲି
No,
ନାହିଁ
that is the
ନା
whole thing.
ଆଇଓର ନାହିଁ
That
ନା ସାଇଣ୍ଟିଫିକ ଅଫିସର ବ୍ଲାଙ୍କେଟ୍ ଦେଖିଲା
all
ବଡା ବ୍ଲାଙ୍କେଟ୍ ଦେଖିଲା ତେଣୁ ଇଏ ଗୋଟେ କହୁଛି ଯେ ମୁଁ ବ୍ଲାଙ୍କେଟ୍ ଇଏ କରିକି ଆଣି ତାକୁ ତାର ପକେଇଦେଲି ଚେଷ୍ଟା କଲି
But I would humbly pray before your lordship, if your lordship sees page 103 again, paragraph 3. This is the IO. He was working as a side.
ଏଇ ଲାଇନ୍ ଟା ଦେଖନ୍ତୁ ଏବଂ ପେଜ 119 ପାସ
ଆଜ୍ଞା
ଯୋଉ PW1 ରେ ଏଗୁଡା
ଆଜ୍ଞା
ହେଲା 1 2 3 4 5 6 7 8 9 9 lines from the bottom
Hello.
page 119
Yes, madam.
I and accused
Tried to open the door of the bathroom by pushing this in.
story of the bathroom by pushing this in
Yes, madam.
ଛାଡି ଦିଅନ୍ତୁ ତାପର line smoke is only coming out so and so it was not coming out of the room through so and so the door was made a single we pushed the door for about 10 minutes and thereafter the tar bolt of the door was broken
Yes.
ତେଣୁ କେତେ ଚେଷ୍ଟା କରାଯାଇଛି ସେ ଡୋର ଟାକୁ ଖୋଲିବା ପାଇଁ ତା ଏଭିଡେନ୍ସ ଅନୁଯାୟୀ ମାନେ ଇଏ ନିଜେ ଚେଷ୍ଟା କଲା ତାପରେ
ଟାର୍ବୋଲ୍ଟ ବି ଭାଙ୍ଗି ଯାଇଛି କିନ୍ତୁ ଇଏ କହୁଛି ନାହିଁ
ତେଣୁ ଏଇ ଯୋଉ ଯଦି ଏଇଭଳି ଭାବରେ ସେ ଡୋର ଟାକୁ ଖୋଲା ଯାଇଥାଏ ଯାହା ହଉଛି ଆପଣଙ୍କର DW1 ର ଏଭିଡେନ୍ସ ତାହେଲେ କେମିତି ନା ଆଇଓ ନା ସାଇଣ୍ଟିଫିକ ଅଫିସର କିଛି ଦେଖିଥାନ୍ତେ ମାର୍କ ଅଫ ଭାଉଲେନ୍ସ ବା କୌଣସି ସେ
Malab, that is not in dispute. I cannot dispute this. Malab, that circumstances is against me.
The things
Yes. We place in the mind at the time of
କେତେ ଗୁଡାକ ଦେଖନ୍ତୁ ନମ୍ବର 1 ଆପଣଙ୍କର ପ୍ଲି ହଉଛି ସେଇଟା ଯୋଉ ବ୍ରୋକୋପନ ହେଇଥିଲା ସେ ଯୋଉ କଣ ସେ ଯୋଉ ଉପରଟା କଣ ଭେଣ୍ଟିଲେଟର ସ୍କାଟର୍ଡ ହିସାବରେ ପଡିଥାନ୍ତା କିଛି ନାହିଁ ଖାଲି କିଛିଟା ତା ତଳେ ପଡିଛି ନମ୍ବର 1 blanket theory is falsified there is no blanket nobody has seen ଆପଣଙ୍କର ଯୋଉ କେସ୍ ହଉଛି ଯୋଉ ନାଇଁ 10 ମିନିଟ ଧରିକି ତାକୁ ଚେଷ୍ଟା କଲା that is not the plea of the defense in the accused statement
yes
but whatever he has stated that is not corroborated by the ମାନେ ଯୋଉ ତାପରେ ଡୋରଟା ଯଦି ମାନେ ଯଦି ବନ୍ଦ ଥାଇକିନି ଘଟଣାଟା ହେଇଥାନ୍ତା ତାହେଲେ ଭିତର ପଟୁ ମାନେ ଡୋର ଭିତର ପଟୁ ବେଶୀ ଜଳି ଯାଇଥାନ୍ତା କିନ୍ତୁ ଏଟା ଜଷ୍ଟ ଦି ରିଭର୍ସ ଯୋଉଟା କି ଜଣା ପଡୁଛି ଡୋରଟା ଯେତେବେଳେ ପୋଡା ହେଲା ସେତେବେଳେ ଖୋଲା ଥିଲା ପରେ ତେଣୁ ଡୋରର ବାହାର ପଟଟା ଡୋରଟା ଏଠି ଓବିୟସଲି ଫଟୋ ଆମେ ଦେଖି ସାରିଲୁଣି ଡୋରଟା ମଧ୍ୟ ବୋଧେ ମାନେ ଭିତର ପଟକୁ ପଡୁଛି ଏଟା ଡୋରଟା ଭିତର ପଟକୁ ତେଣୁ ଭିତର ମାନେ ଏଇ ପଟଟା ଆଫେକ୍ଟେଡ ହେଇଛି ବାହାର ପଟଟା ଯୋଉଟା କାନ୍ଥ କଡକୁ ରହିଛି ସେଟା ଆଫେକ୍ଟେଡ ହେଇଛି
କିନ୍ତୁ if your lordship will see the PW10
ଯୋଉ କହିଛି ଦୁଇ ସାଇଡ ଟା ହେଇଛି
yes ଦୁଇ ସାଇଡ
ଦୁଇ ସାଇଡ ତ ଅଛି କିନ୍ତୁ ବେଶୀ କୋଉ ପର୍ସନ ଟା ଏକ୍ସପୋଜ ହେଇଛି
ସେଟା ଆଇଓ କହିଛି
PW11 କହିଛନ୍ତି both sides ର bulging ଅଛି both sides ର point ଜଳିଛି sir he has not specified that କୋଉଟା କିନ୍ତୁ scientific examination एकदम डेफिनेट रिपोर्ट दउचंती जे बाहर पर्सन ता बेसी जलिछि भीतर पर्सन रिलेटिवली कम
नेक्स्ट इज दैट व्हाई शी वुड कमिट सुसाइड आमे जोटा प्रश्न आपन पचारलु निजरो गोटे छुआटे अछि छुआटा जाईची से दिन गणेश पूजा थिला जाईची मंदिर को आपन कहउचंती गंडगोल किछि हेनी सी प्रेग्नेंट थिला 4 मासर गर्भवती थिला so why she would commit suicide
पिला कहउची गंडगोल चाली गला बेलको
मतलब one thing I will just say before I take your lordships to other level मतलब if your lordship says that I put a question to myself there may not be any need to kill herself but there is no case made out by the prosecution that I have murdered the deceased
no
मतलब here this I'm finding with my limited experience in this branch of law, I'm I am seeing one thing, my lord. If suicide is ruled out, can it be a murder? But what I am seeing from the evidence, subject to appreciation by your lordship, that it is also not a case of murder. It is also not case of murder.
The doctor's opinion
Yes,
is not conclusive.
conclusive.
କାରଣ ସିଏ କହିନି ଡକ୍ଟର କହିନାହାନ୍ତି ଯେ ଇଟ୍ସ ଏ କ୍ଲିୟର କେସ୍ ଅଫ ହୋମିସାଇଡ୍
Yes.
ସେ କହିଛନ୍ତି ଯେ ଇଟ୍ ମେ ବି
Homicide or-
ତେଣୁ ବାକି ଯୋଉ ରହିଲା ତେଣୁ ଏଇ ସର୍କମଷ୍ଟାନ୍ସ ରେ ଯଦି ଗୋଟେ କେସ୍ କୁ ଛଡାଯିବ ତେଣୁ ସେଠି ଆସିଲା ଯେ ଅଦର ଏଭିଡେନ୍ସ କଣ ଆସିଛି
Yes.
ଅଦର ଏଭିଡେନ୍ସ ରୁ ସୁଇସାଇଡ ଟା ମୋର ପ୍ରୋବାବଲ ହଉଛି
No,
homicide.
Sir, from this side, sir, I will take to 98. PW 11 10 to 4 page भूल अछि मोर पेज एपटे आगे 10 टा करबा हाँ हाँ sir, if the lordship may see paragraph 3 at page 103.
We are expecting you to finish it so that we can.
Yes, well, I will finish it.
You don't expect that on Saturday we have to.
Well, I will also not like to stay after lunch because
Yes.
well, now Navratri Puja I cannot.
No, that's all right.
Well, paragraph 3. From the spot, I seized one white plastic jerrycan containing some kerosene oil in the upper portion, which was burnt and melt. One matchbox. Well, he gives a detail. One soap case melted at lower portion. Your lordship will see one plastic mat which burn marks. One soap case melted at lower portion. Well, scientific examination did not see this. Scientific examination was called by him. He did not see anything. He says everything is intact. This IO says one plastic mug which burn marks. One soap case melted at lower portion. 5 pieces of broken bangles. 4 pieces of blue color broken bangles. One necklace appearing to be gold, 2 sides were deformed, and 18 small pieces of glass. But here your lordship see 18 small pieces of glass. It must have been scattered inside. He is not giving
specific. Your evidence is also specific.
Yes. Exhibit 2, already marked in the said season is, I have examined some witness, I received injury to your lordship kindly.
What a common, let us say apply common sense. ଏଇଟା ଗୋଟେ ଧର କାଚ ଭାବ
ଆଜ୍ଞା
ତାକୁ ଆପଣ ବାହାରୁ ଗୋଟେ ଯେବେ ଭାଙ୍ଗିବେ ଏଇଟା କଣ ଗୋଟେ ପର୍ଟିକୁଲାର ଜାଗାରେ
No, sir, it will be scattered. Yes, it will be scattered.
ଏଇଟା ପୁରା beneath the body.
Sir, beneath the body, no, I would try to project before your lordship that when the body was, the discus was burning, the glass panes of the ventilator was broken. As per PW2, the water was thrown. Probability can come up that the glass was broken and water was thrown. Or it can also be stated that glass was not broken, water was thrown. 2 sides can come up.
ନାଇଁ glass was not broken ବୋଲି ତ ଆପଣ glass was not broken and it was there is every chance that it was shown that
You have been broken.
broken and some pieces were just kept beneath.
Sir,
ଆପଣ ଯୋଉ ପ୍ରକାରେ କହୁଛନ୍ତି ଯଦି ସେଇଆ ହେଇଥାନ୍ତା ତାହେଲେ ଗ୍ଲାସ ଗୁଡାକର ପୋଜିସନ ଅଲଗା ଟାଇପ ର ହେଇଥାନ୍ତା ମାନେ ସ୍କାଟର୍ଡ ହେଇ ପଡିଥାନ୍ତା ଯୋଉଟା କି ଆପଣ ବର୍ତ୍ତମାନ ଆମେ ଆପଣଙ୍କୁ କହିଲୁ ସେପଟେ ଆଉ ତାପରେ ଦ୍ୱିତୀୟ କଥା ହଉଛି once somebody come in contact or access to the bathroom କୁ ଚାଲିଗଲା ପରେ ଆଉ ସେପଟେ କାହିଁ ଜଣେ ପାଣି ଆସି
ନାଇଁ ସାର୍ ଆଗରେ ପାଣି ପ୍ରଥମ ସାର୍ ଆପଣ ଯଦି ଏଭିଡେନ୍ସ ଗୁଡା ଦେଖିବେ
ଆପଣଙ୍କର କହୁଛନ୍ତି ଆଗରେ ପାଣି ପକେଇବାକୁ ଚେଷ୍ଟା କଲା କିଏ କଲା ଆପଣ D.W.1 ବି ସେ କଥା କହିଛି କି ଯେ କେହି ଗୋଟେ ଆଗେ ଚେଷ୍ଟା କଲା ସେପଟେ ଆପଣ ପୁରା ଗୋଟେ ସଫେଇ ସାକି ଦଉଛନ୍ତି
ସାର୍ ସଫେଇ ସାକି ସେ ବିଷୟରେ କିଛି କହିନି ସଫେଇ ସାକି କହିଲେ ଆମେ ଟ୍ରାଏ କଲୁ ପ୍ରଥମ ଥର ଖୋଲିଲେ ତାପରେ ଆଉ ଜଣକୁ ଡାକିକି ଆମେ ଭାଙ୍ଗିଲୁ 2 persons, one was the accused and one was DW1.
And who is not talking of PW2?
He has not stated at least.
PW2 has not seen the presence of the DW1. DW1 has not seen the presence
Sir,
of the
there were 4 persons at this spot.
But at least DW1 must have been seen by PW2.
Sir,
He did so many things.
Sir, my answer would be This occurred in 95. The evidence was taken in 2023.
No, that is all right. But some events are such,
Yes,
which remains in memory almost.
meticulous things.
It might get blurred, that is there, but we cannot say that.
Some memories sometimes get blurred. No. But the basic thing which I am saying before your lordship, that there were the prosecution could not examine any other witness who were present in the inquest, who were present at the spot, they have not brought him to evidence. Because PW2 said one Rothel and I threw water from the ventilator. He has not stated that the ventilator was broken. I'm correct. I'm aware of that.
That is the argument then. What prevented this man was not there as a witness, charge sheet witness. D21 was not a charge sheet witness.
No, he's a charge sheet witness.
Charge sheet witness.
Yes.
And
prosecution did not examine him.
Achha.
He was a charge sheet witness. Man. And if your lordship sees that paragraph 4, on 30/8/95 at 2 p.m., I also seized original command certificate, blood sample of the deceased, letter of the specialist FMT Capital Hospital, 5 pieces of red colored bangle, 5 pieces of white bangle, 8 pieces of broken blue bangles, 10 pieces of broken golden bangle, residual portion of burnt blouse, burnt red saya, burnt blue printed sari, and the dead bodies. But if this person who had come first would see this type of bangles scattered in the bathroom, how did the forensic expert, whose expert's evidence is relied upon by the Lanot trial court, could not see anything. He did not see the burnt bucket. He did not see the burnt soap case. He only said that these glasses were lying beneath the body. Iron mug and ear was kept intact. And only stated that jerrycan was burnt. He did not see the melted soap case of burn marks on the mug. Necklace he did not see. He did not see bangles.
No, necklace is there, no?
No, necklace is by IO.
So by then it was already seized. By the time the scientific team was pressed into service.
No, my lord, Lordship kindly.
Time is different.
Yes, your Lordship kindly.
But the victim had the time to see that the matchbox is to be kept in a very proper place. Because 2 sticks are still there in the matchbox.
Matchbox was there.
Because after immolation, she put it in such a place that it should not get damaged.
My lord, if I have burnt it, why should I keep that matchbox inside, my lord?
That you cannot say.
My lord, should I create circumstances to kill myself?
It is always, it's the principle of law.
ଆପଣ ଯଦି ମ୍ୟାଚଷ୍ଟିକ୍ ଟା ସେଠି ନ ପକେଇଥାନ୍ତେ ଖାଲି ପଳେଇ ଆସିଥାନ୍ତେ ଅନ୍ୟମାନେ ସନ୍ଦେହ କରିଥାନ୍ତେ ତାହେଲେ ଯେ କିଏ ବୋଧେ ନେଇକି ପୋଡିକିନି ତା ଭିତରେ
the scientific said it is untouched. I put a question to myself. How many glass pieces were found?
No, it is true. Rightly, you are arguing for the sake of your client. It's correct, but something is also beyond that. Yes, kindly proceed.
My lord, may kindly see the cross-examination. My lord, paragraph 9. It is also fact that as per the version of the accused, when he got up next day morning, found his wife sleeping, and since it was day of Ganesh Chaturthi and she was still on the bed, there was a quarrel between two. It is also a fact, as per the statement of the accused, as he was not inclined to let his son visit Ganesh Puja, there was a quarrel between him and his wife. It is a fact that the accused has stated that on the day he was reading newspaper inside his bedroom, and at that time heard the screaming of his wife, and in response he rushed to the bathroom along with the kitchen boy and one Kishore Bera and Ramchandra Panigai. Ramchandra Panigai was also not examined. It is also a fact that as per the version of the accused, he and others threw water into the bathroom through its skylight and thereafter broke the door of the bathroom and went inside and found the wife has committed suicide. That the throwing of water was also stated by PW2. The bathroom and the bedroom are intervened by store, kitchen room and dining room, which your lordship has just now seen from the spot map. I need not. It is also fact that bathroom is not visible from the bedroom as they are intervened by store, kitchen and dining room. My lord, may kindly see that the occurrence had taken place in the government quarter, which is a flat type. One Lakshmanaji MLA Rairanpur was the immediate neighbor of the accused at the relevant point of time. The other neighbors were such and such, such and such. On 3/7/95, I issued requisition to CMO, Captain Hospital to depute FMT specialist to the spot. My lord, when he saw these glass bangles scattered and the body, thereafter he has requisitioned FMT expert to come to the spot. And FMT expert, my lord, if that time the IO was present and the glasses were scattered, my lord, where will I get the time to gather and keep it inside the body or out just below the body? So the IO was the first person who had seen the spot, and thereafter he called the FMT to examine. And FMT report, which PW8, which is my basically basis of my sorry, PW8, FMT has not been examined. Rather, the scientific examination is PW8. And FMT specialist remained on the spot. I cannot say how much time FMT specialist remained. No inspection memo or any kind of note was handed over to me by the FMT specialist. But heroes has not been examined. I had not conducted any query from the FMT specialist during my inquiry. The IOC and PS was present at the spot on that point of time. It is a fact that the SP, IO of the case, including IIC of the PS, were present at the spot. Ordinarily, senior officers do not visit the spot case of UD cases. Till the time of my leaving the spot, the accused all along present with me and cooperated in inquiry. I have examined the inmates of the spot house, its neighbors, the parental family members of the deceased during my inquiry. I have examined the mother, two brothers and the sister of the deceased during the aforesaid inquiry. It is a fact that one of the brothers of the deceased, namely Simanchal Gomango, was serving as assistant manager in Bank of Baroda at the relevant point of time. The mother, two brothers and sisters of the deceased had visited this PS in connection with alleged occurrence. I have sent the above family members to hospital at the time of postmortem over the dead body of the deceased. None of the family members or inmates of the house, besides the neighbors, ever alleged that the accused to have killed his wife during my inquiry. It is a fact that I had noticed one burn injury on the person of one of the inmates of the house, namely Kishore Chandra Behra, who is DW1. During the time of occurrence, I had also noticed number of injuries such as abbreviations with the accused at the point of time. No one lodged a written complaint with me during time of inquiry, alleging that the accused to have killed his wife. The spot house is situated near a crowded place. One Dasrathi Jena and Balabhadra Maji MLA Nandla were present at the time of inquest. Well, those persons had signed the inquest report, but they were not brought to the dock.
अच्छा ये लाइन टाको आसिले DW1 नो प्लीज
आगे।
एक्सप्लेन करो DW1 पेज 117
Hello.
paragraph 3
Yes, Malu.
Fourth line of that paragraph number 3.
Yes, Malu. Malu, she's saying at around 7 a.m.
At around 7 a.m. while I was going to the bathroom, the wife of the accused came and restrained me.
Yes, Malu.
She told me to wait. Then she entered inside the bathroom to take her bath and bolted the bathroom from inside.
Yes. Yes, Malu. Yes.
Now you come to the cross-examination. Cross-examination page number 119 question.
Hello.
ହେଲା 119 ने आपण paragraph number 7 ର 1 2 3 4 5 fifth line को आसो
Malu.
Hello. At that time, I was cleaning my teeth inside the bathroom. जो bathroom भीतर घटना ହେଇଛି ହେଲା, soap, one plastic bucket, one plastic mug were kept inside the bathroom. ଏତିକି ଜିନିଷ ଥିଲା.
Yes.
Two skylights were there in the bathroom. The lock of the bathroom was properly functioning. Skylight size was this. Glass pieces were arranged in 4 rows. The wife of the accused was sari and brought one sari with her. When the wife of the accused came and told me to leave the bathroom, I left the bathroom and came outside the room. ଏତିକି ଆପଣ ଆମକୁ ବୁଝାନ୍ତୁ ଯୋଉ ବାଥରୁମ ରେ ଏଇ DW1 ଥିଲା ଦାନ୍ତ ଘଷୁଥିଲା ଏବଂ ସେଇ ବାଥରୁମ ର ପୋଜିସନ କଣ ଥିଲା, ସାବୁନଟେ ଥିଲା, ପ୍ଲାଷ୍ଟିକ ବକେଟଟେ ଥିଲା, ପ୍ଲାଷ୍ଟିକ ମଗଟେ ଥିଲା ହେଲା, କିରୋସିନ ସେଠି ନଥିଲା. ଜଷ୍ଟ କିପ୍ ଇନ୍ ମାଇଣ୍ଡ
ମାନେ
କିରୋସିନ
ନା,
ଜାର୍ ସେଠି
ନା.
ନଥିଲା. ଷ୍ଟପ୍ ଦେୟାର. ଇଏ ଡିସିଜ୍ଡ ଆସିଲା, କହିଲା ତମେ ଏଠୁ ବାହାର, ମୁଁ ଗାଧେଇବି ହେଲା. ତାପରେ କଣ କଲା,
One ଶାଢୀ only.
ହଁ ଶାଢୀ, ସିଏ କଣ କଲା ନା ତା ବାହାରକୁ ବାହାରି ଗଲା. ଇଏ ବନ୍ଦ କଲା ହେଲା, ବନ୍ଦ କରି ଇଏ କଣ କଲା ନା ନିଜେ ବ୍ରଶ କଲା ବାହାରେ ଯାଇକି
Yes.
ସେଇଠି ହେଲା. ଏଇଆ ଯଦି ଆପଣଙ୍କର କେସ୍ ହଉଛି ହେଲା, ତାହେଲେ କିରୋସିନ ଜାର ଟା କୋଉଠୁ ଆସିଲା ଯେ ସିଏ ସେଠି ସୁଇସାଇଡ କରିବ?
Yes. Well, my lord is absolutely correct in this. But this soap plastic mug is corroborated by IO.
That is there.
Soap was burnt,
That was he has said.
plastic mug was also burnt. My lord, this it can be safely said that the deceased had not carried kerosene. And PW2 or PW2 most probably has stated that kerosene was kept inside the bedroom under the cot.
You want to see the position, you just come to that case map.
Yes, ma'am.
Court map.
Yes, ma'am.
ଯୋଉଟା ଲାଷ୍ଟ ପେଜ ରେ ଅଛି
ଆଜ୍ଞା
ସେଠି ଦେଖନ୍ତୁ ଗୋଟେ ଇଣ୍ଡେକ୍ସ ଲେଖା ହେଇଛି
ଆଜ୍ଞା
ଲାଷ୍ଟ ପେଜ ରେ.
ଆଜ୍ଞା
ଇଣ୍ଡେକ୍ସ ରେ DS 18/1 କୁ ଏନଲାର୍ଜ କରାଯାଇଛି. 18/1 ହଉଛି ଆକ୍ୟୁଜ୍ଡ ର ଘର ବା deceased ର.
informant.
ତାର ଯୋଉ 4 ନମ୍ବରଟା ଦିଆହେଇଛି ଦେଖନ୍ତୁ ଲେଖା ହେଇଛି ସି ପରେ ଯୋଉଟା ହେଡ୍ କଟ୍ ଅଣ୍ଡର ହ୍ୱିଚ ଦି ଜାର୍କିନ୍ ୱାଜ କେପ୍ଟ. ସେ ଇଏଟା ଦେଖନ୍ତୁ ଡାଇନିଂ ହଲ ର ସେଇ ଚିହ୍ନଟା ଦିଆହେଇଛି ସେଠି, ସେଇ ଯୋଉ ଇଏ ଚିହ୍ନଟା ଯୋଉଟା ଏମିତି ସାଇଜ ଡାଇନିଂ ହଲ ନାହିଁ, ଯୋଉଟା କିଚେନ ସାଇଡ ଗୋଟେ
ଆଜ୍ଞା.
ଡାଇନିଂ ହଲ ଅଛି,
ଆଜ୍ଞା
ଡାଇନିଂ ହଲ ଠିକ ସେମିତିଆ ଗୋଟେ ସାଇଜ ର ଦେଖନ୍ତୁ ଦିଆହେଇଛି.
ଆଜ୍ଞା
ତାମାନେ ସେଇ ଜାଗାରେ ବେଡ କଟ୍ ଗୋଟେ ଥିଲା ଯାହା ତଳେ ହିଁ କିରୋସିନ ଜାର୍କିନ୍ ଥିଲା.
yes
ବୁଝିପାରିଲେ ନା?
yes ma'am.
ଆଉ କୋଉଠି ସେମିତିଆ ଚିହ୍ନ ନାହିଁ ଦେଖନ୍ତୁ
ନା
ଏଣ୍ଟାର ଇଏରେ.
ନା
ତେଣୁ ସେଇ ଜାଗାରେ ହିଁ ବେଡ କଟ୍ ତଳେ କିରୋସିନ ଥିଲା.
yes
ତାହେଲେ ଗୋଟେ ରୁମ୍ ଭିତରକୁ ଯେତେବେଳେ ଡିସିଜ୍ ଗଲା ଗାଧେଇବା ପାଇଁ, ସେ ରୁମ ରେ ସେତେବେଳେ ଆପଣଙ୍କର କେସ୍ ଅନୁଯାୟୀ DW1 ହିଁ ତାକୁ ୟୁଜ କରୁଥିଲା, ଦାନ୍ତ ଘଷୁଥିଲା. ଇଏ ଗଲା ତାକୁ କହିଲା ତୁ ବାହାର, ମୁଁ ଗାଧେଇବି ହେଲା. ତେଣୁ ସିଏ ପଶିଲା, ଗୋଟେ ଶାଢୀ ଧରିକିନି ଭିତରେ ପଶିଲା. ଭିତରେ କଣ ଥିଲା ମଧ୍ୟ ସେ କହୁଛି, ବାଲ୍ଟି ଥିଲା, soapଟେ ଥିଲା, ପ୍ଲାଷ୍ଟିକ ମଗଟା ଥିଲା. That means there was no kerosene jar inside,
yes
no matchstick inside.
yes
ଏଇ ଅବସ୍ଥାରେ ଇଏ ବାହାରକୁ ଆସିଲା, ସେ କବାଟ ବନ୍ଦ କଲା ହେଲା, କବାଟ ବନ୍ଦ କରି ଦାନ୍ତ ଘଷିଲା. ତାହେଲେ ଡିସିଜ୍ ଆପଣ ଯୋଉ କହୁଛନ୍ତି ଏଇଆ ଯଦି ଘଟଣା ହେଇଥାଏ ଆପଣଙ୍କର ସାକ୍ଷୀ, ତାହେଲେ ଡିସିଜ୍ କିରୋସିନ କୋଉଠୁ ଆଣିଲା ଯେ ସୁଇସାଇଡ କରିବ?
my lord, if your lordship sees in that his evidence only, when the wife of the accused came and told me to leave the bathroom, I left the bathroom and came outside of the room. I was cleaning my teeth from 10 to 15 feet distance from the said bathroom.
ସେଇଠୁ ଆସିକିନି ତ ମାନେ ବାହାରେ ଆସିକି
ବାହାରେ. My lord, if your lordship sees the spot map, my lord, there is a way from this bathroom to the dining room where the kerosene is kept. There is a way. My lord, there can be a probability that she went inside, told DW1 to vacate the premises and went inside. Plastic mug, soap is found inside the bathroom, which has been stated by the IO. That is not in this book. My lord, it cannot be ruled out that she might have come again.
ଆଉଥରେ ବାଥରୁମ ବନ୍ଦ କଲା ପରେ ପୁଣି ଆଉଥରେ ଆସିକିନି ସେଠୁ ଏଇ ଯୋଉ ଏଇଟା ନେଇକି
ମାନେ ଯଦି ମୋର ଇଣ୍ଟେନସନ ଅଛି ମତେ ସୁଇସାଇଡ କରିବାର ଅଛି, it is not improbable that she may not come out again. She may not come.
ଆଜ୍ଞା ସିଏ ଯେତେବେଳେ ପ୍ରଥମରୁ ଗଲା ସିଏ ତ ଯଦି ତାର ଇଣ୍ଟେନସନ ଥାନ୍ତା ସିଏ ତ ଶାଢୀରେ ଗୁଡେଇକିନି ସେ
କିରୋସିନ ଜାର୍କିନ ଟା କେତେ ବଡ ତ ପ୍ରୋସିକ୍ୟୁସନ କୋଉଠି କହିନି ସାର୍। କିରୋସିନ ଜାର୍କିନ ଟା ସାଇଜ କଣ ସାର୍, ଯୋଉ ମେଲ୍ଟ ବି ହେଲା କି ଯୋଉ ହାଫ ବଣ୍ଟ ହେଲା ତାର ସାଇଜ ସାର୍ ମପା ହେଇନି।
ଯଦି ସେଇଆ
ସାର୍ ଯଦି ମୁଁ
ସେଇଆ ଯଦି କେସ୍ ହେଇଥାନ୍ତା ତାହେଲେ ଇଏ ତ ପୁରା 15 ଫୁଟ ଦୂରରେ ଛିଡା ହେଇକି ଦେଖୁଛି, ସେ କହୁନି କି ଯେ ମୁଁ ଆସିଲି ବାହାରେ ତାହେଲେ ସେ ଦେଖିଥାନ୍ତା ନିଶ୍ଚୟ ଇଏ ପୁଣି ଆସିଲା ଗୋଟେ ନେଇକିନି।
It was 95 occurrence. His evidence was in 2023. Alleged incident took at 7:31. So 7 a.m. She was asked to, the deceased asked, you have to come out of the bathroom. It was 7 a.m. But the incident took place at 9 a.m. Sir, ये DW1 କହିଛନ୍ତି ତାଙ୍କର ଇଏରେ the alleged incident took at 7:30 a.m. on the relevant day.
ବୋଲେ ବାଥରୁମ ଯିବାର କିଛି ସମୟ ପରେ ମରିଗଲି ସାଉଣ୍ଡ ଆସିଲା।
ହଁ,
ତାହେଲେ then 9 story is wrong. Which one is correct?
Sir, 7
That
sir,
is not these are this not
sir, 7 ତାକୁ deceased କହିଲେ ଯେ ତମେ ଯାଅ, this vacate, I want to take that. And he comes out. And the spot map, sir, shows there is a road to the place where the kerosene was kept. Maybe a probability may be that after, sir, if I am carrying kerosene jar to a bathroom, let me hold that if I am carrying kerosene jar, and DW1 could have watched that she was carrying kerosene jar. Sir, whether this incident would have ever happened?
ନାଇଁ ଆଉ ବାଟ କୋଉ ପଟେ ସେଇ ଯୋଉ
Sir, ଆପଣ ସେ ସ୍ପଟ୍ ମ୍ୟାପ୍ ଟା ମାନେ ଦେଖିଲେ
ପଟ୍ଟମ୍ୟାପରେ ଆମେ ଦେଖିଲୁ ଲାଟ୍ରିନ୍ ପାଖରେ ଘଟଣା ହେଲା।
ଲାଟ୍ରିନ୍ ପାଖରେ ଏଇ ଯୋଉ
ଘଟଣା କିରୋସିନ ଜାର ଥୁଆ ହେଇଛି ଆପଣଙ୍କର ଡାଇନିଂ ରୁମ ରେ। ଆଜ୍ଞା, ଡାଇନିଂ ରୁମ ରୁ ଗୋଟିଏ ବାଟ ସେଠି ଅଛି ଦେଖେଇଛି, ୱେ କୁ ଆସିବ, ୱେ ରୁ ଆଉ ଗୋଟେ ବାଟ ଦେଖଉଛି ଯୋଉ ପଟେ ଦେଇକିନି ଆପଣଙ୍କର ବାଥରୁମ ରେ ପଶିବ। ଦିଟା ଯାକ ଲାଟ୍ରିନ୍, ତା ଦେହରୁ ଗୋଟିଏ ଲାଟ୍ରିନ୍ ରେ ବ୍ୟବହାର କରୁଥିଲା DW1 ଆପଣଙ୍କ ରହୁଛି ହେଲା। ସେଇ ରୁମ ଟାକୁ ଡିସିଜ ରାଶି କହିଲା ତୁ ବାହାରେ ମୁଁ ବ୍ୟବହାର କରିବି, ଆଉ ସେ ସେତେବେଳେ ଶାଢୀ ଧରିକି ପଶିଲା ପରେ କବାଟ ଟା ବନ୍ଦ କରିଦେଲା। ଇଏ ସେଇଠୁ ପାଖରେ ଛିଡା ହେଇକି ଦାନ୍ତ ଘଷିଲା। ଏଇଆ ଯଦି ଆପଣଙ୍କର କେସ୍ ଅଛି ତାହେଲେ ସେ ଏଠୁ ଡାଇନିଂ ରୁମ ରେ ଥିବା କିରୋସିନ ଇଏଟା କେମିତି ଅଟୋମେଟିକ ପଳେଇ ଆଇଲା?
ସାର୍ ଯଦି କିରୋସିନ ନେଇକି, ସାର୍ ଆଇ ପୁଟ୍ କ୍ୱେଶ୍ଚନ, ମୁଁ ଯଦି କିରୋସିନ ଜାରଟା ନେଇକି ଯିବି ଆଉ ସିଏ DW1 ଦେଖିବ ମୁଁ କିରୋସିନ ଜାରଟା ନେଉଛି, ସାର୍ can the incident happen? ସାର୍ ଯଦି କିରୋସିନ ଜାରଟା ମୁଁ ନେଇକି ଯିବି, sir, anybody will say that yes, something fishy is going on. So to avoid that, the deceased might have come out and taken the kerosene jar. This possibility also cannot be.
Yes, probably that could have been, but that is not your case. Your case is that after some time, smoke was coming out.
Sir, what is that?
Your case.
Sir, what is that?
You are not saying that after 7:30 there was.
Sir, what is that sometime? Sir,
No.
Sir, moreover,
no. How can we?
Sir, but jarkin ta keda bada hobe?
No, jarkin কথা নয়. After some time means he is very much watchful. After some time means it is not 9:30. So after 2 hours, after 3 hours, it is not the case.
Sir,
after some time, the person has gone inside.
2023 is the evidence. 95 is the incident. 2023 is the evidence in the doc. Memories may fail, memories may fade for some time. But your lordship, while deciding this, has to gather that if a person will see that he is carrying a jerry can, will you not stop her? Will you not stop? Then the entire episode would not have happened.
No. Such an analogy could be given to the evidence also. Had the witness not been able to speak many, but the witness is giving a very, very precision statement. See, very minute, sequentially. Otherwise, you could have said, yes, it is up to block. This evidence has come after 30 years.
Yes, 2023. 28 years after. কিন্তু স্যার 161 সে 8টা কইতলা আর 161 টা দেখিবে ডিডব্লিউ
That is the proximate. That is
Yes.
what I am saying. That is we also have to see the 161.
8টা কইছে
That is a proximate time. It is not that
মানে
from the tenor of your
what
statement we can say
yes
that it could not have been more time gap. So that is how one thing comes to mind, that yes, how long the body was allowed to remain in fire.
Yes.
That it got charred, you did all these things, but it happened so quickly within a very short time span that you tried to throw water from the ventilators, again you are coming and pushing it, and the patient is died. Patient has died. It's not that she is in a moribund condition and she was shifted to hospital and while shifting she died. It's not the case. She has died, maybe out of shock.
yes
But here it is suffocation, not shock. In most of the cases, it is asphyxia or shock, but here it is asphyxia because of suffocation. So how long that took? The victim was inside the room.
মানে it is he says that in my I have given my reply on the mode of death was asphyxia, shock and hypoxia.
Hypoxia is that.
Yes.
Ah.
মানে shock is also there. The doctor has stated that.
Has to. Shock is apparent. Any kind of death has to be shock first.
And what my lord,
Trauma is there. Once trauma is there, shock is there.
my entire endeavor before your lordship
Correct.
is
Correct.
my entire endeavor before your lordship is that even if your lordship rules out the possibility of suicide,
And you are going the other way, that if it is ruled out, then can it be taken as homicidal?
yes,
But other circumstances.
yes, whether those circumstances put up a chain for homicidal death. My lord, I would humbly argue before your lordship that the chain by the prosecution is not complete, because if your lordship sees at the IO, he says the persons who signed the inquest report as witness, they were not called. My lord, all the witnesses, the FMT specialist is not a witness to the above inquest report. That is also the statement in the cross-examination by the PW10, my lord. PW10. And moreover, my lord, PW11 also says that PW10 and 11 also says that there are many persons who are at the near proximity to the house. It was a crowded place, near proximity. There were shops outside the MLA quarters. There were proximity. It was a cluster of houses, and the houses were very close to each other. The MLAs were present in their house. They had rushed to the spot. None of them stated that the appellant had killed the deceased. Sir, ଏମାନେ ଯୋଉ ଲୋକ ଇନକ୍ୱେଷ୍ଟ କଲା, the ଲୋକ ରଥ sir, one Panigrahi, here the statement is that none of them produced by prosecution.
ସମସ୍ତେ କହୁଛନ୍ତି ବାଥରୁମ ଭିତରେ ବଡି ପଡିଥିଲା,
Sir.
ପୋଡା ଅବସ୍ଥା ବାଥରୁମ କବାଟ ମେଲା ଥିଲା।
Sir, କିନ୍ତୁ କେହି କହୁନାହାନ୍ତି ଯେ ମାରିଛନ୍ତି। Sir, ଏମାନେ ଇନଫ୍ଲୁଏନ୍ସ ଡ୍ର କରୁଛନ୍ତି। Circumstance sir,
ଆପଣ କହିବେ ନା କିଏ କହିବ?
sir, circumstance ବି ସେମାନେ ମେକ୍ ଆଉଟ୍ କରିପାରୁନାହାନ୍ତି ଯେ ମୁଁ ମାରିଛି ବୋଲି। Sir, ସୁଇସାଇଡ ହୋଇ ନପାରେ।
ଲୋକଟା ଆସି ଯାହା ଦେଖିବ ସେ ସେଇଆ କହିବ।
ସୁଇସାଇଡ ନ ହେଇପାରେ। Sir, I may fall on that scope that it's a suicide. Let me concede for the moment. Let me argue, not conceding,
Right.
that I may fall on the part of suicide. Then prosecution has to justify that yes,
There is no
the chain is complete. My humble submission from the entire reading of the evidences And PW8 and PW10, if your lordship may see, the chain is not complete. There are contradictions of PW8 and PW10. PW11 also. So therefore, my lord, I would humbly pray before your lordship that even if I fail on suicide, I cannot be convicted under 3
All right.
It is an accidental death.
Accidental.
That is also
No, not accident.
but that are
Sorry,
Accidental.
it may be a suicidal death that I have not killed my wife. I'm sorry, it slipped from my mouth.
Accidental is totally different.
Yes, that's not just it slipped from my mouth. It's a suicidal death and not a case of killing of the wife.
Okay, okay.
Malad, I have given few judgments in my note. 2 other judgments I'll provide.
Yes, Mr.
Malad, can I take leave for 2
Yes,
minutes?
yes, yes. Yes, Mr. Tripathi.
first come to the point that
Please use the mic properly.
yes, that this appellant was present in that house first. He has to explain in which circumstance his wife was born. That was not explained by him. Second is that injury caused on the appellant. PW11 stated that some mark of injury on the dorsal of the right middle finger and ring finger and the right hand side, and being asked, that appellant told that he was suffering from erythema. So he was sustained this type of injury. And after medically examined, it was opined by the doctor that there is no sign and symptom of erythema on the right hand side. Then came to the first PW8 Miller, the scientific officer. You had seen the door of that bathroom was not tampered with or broken or something else. You seen that no mark of violence was dictated on the door frame, door bolt, and door bathroom. And as per the version of all the witnesses, they have, as per DW1, they pushed that door to open 10 minutes. And that the inner lock was broken. And that is not found in that scientific as well as that IOS report. And second is the uniformity of the smoke preserved in the bathroom. If one person is burning, the smoke will be there. There is nothing. And one hematoma was found on the head of that lady, deceased. And secondly, the carboxyhemoglobin was not found on her blood. That is, if she died due to the burn injury, some carboxyhemoglobin was found on her blood. That was not found.
But the doctor opines that there is choke.
Choke.
Choke means that means what he says,
yes,
that the lady was not dead completely before she was burned.
Yes.
She had
some suffocation.
Suffocation. That is why something has also entered into the trachea,
yes,
right? And so soup materials were also there.
Yes.
Total death means there was no chance of entering all those things.
So it was found that he was first assaulted on her head, then she fell down, and then kerosene was poured on her, and she was found. And that is that ventilator, the broken glass of the ventilator. Kindly have a glance to the spot map. Sorry, Miller, DW1. There in para 7, in the middle portion, he stated that there is no way to go back to the said MLA quarter. If there is no way to go back to the MLA quarter, and how will they go and broke the ventilator? The glass was broken. Some pieces of glass was in under that body, Miller. How it is possible?
Just a minute. Let us see.
Para 7, middle portion.
Koda.
Para 7 just at the middle.
DW1.
DW1.
Yes.
Difference. There is no
way to go back of the said MLA quarter.
Who line that is outside?
This middle.
Middle portion. I left the bathroom and came out. I was cleaning my teeth. 10 to 15 distance of the said bathroom. There is no way to go back to the said MLA quarter.
ତାମାନେ ଜଣା ପଡୁଛି ଲାଟ୍ରିନ୍ ଟା ହିଁ ହଉଛି ଏଣ୍ଡ
ତାପରେ କିଛି
ସେଇ ସ୍କାଟର ଲାଗିଛି
ଆଉ ରାସ୍ତା ନାହିଁ
ତାର ହଁ ତେଣୁ ସେପଟକୁ ଯାଇକିନି
ଜଣେ ପାଣି ଫୋପାଡିଲା ତ ଭାଙ୍ଗିକି ଇଏ କଲା that is totally false. ତାପର ଲାଇଟ୍ ଆସିଗଲେ
So according to you, this defense witness is not speaking anything about going to the backside, pouring water from the ventilator, straight only on the bathroom door.
ସେ ତ ଶୁଣିଲା ଆସିଲା
ସିଧା bathroom.
ସିଧା ମାନେ ଚେଷ୍ଟା କଲା ତାକୁ ଡାକିନା 10 ମିନିଟ ପିଟାପିଟି କଲା ପରେ ଘଣ୍ଟା ଭାଙ୍ଗି ଗଲା
accused ସାଙ୍ଗରେ
ହଁ
and he also not stated that there is kerosene was kept inside that bathroom.
ନା ସିଏ ନିଜେ ଦେଖିଛି ଏତିକି ଜିନିଷ ଥିଲା
one plastic mug, one plastic bucket and soap.
ହଁ ଏତିକି ଥିଲା ଏବଂ ସିଏ ବାହାରିକି ଆଇଲା ଇଏ ପଶିଲା ଆଉ
and she came with only one shirt.
ହଁ ସେ
then the appellant can say under 106 Miller, what happened? Onus lies on him.
This IOS examination was over by February 2018, as it appears.
Yes.
Then the accused statement was recorded in 23. Why? If you will come to the IOS evidence,
yes,
IO is PW11.
Yes, 2018.
2018 February ମାସରେ ସରିଗଲା ये जो accused statement record ହେଇଛି 28 ମାର୍ଚ୍ଚ 2023 ରେ
he may not be available coming to the court because he's in 23 after 5 years.
5 years.
So he was not available definitely to the court.
Not he stayed
order sheet it order sheet थे order sheet ଏଇଠି ଦେଖି ଦଉଛି
ହଁ ସେଠି ଷ୍ଟେଟ୍ 12/2/2018 ପରେ
ଲାଷ୍ଟ ଇଏଟା ଅଛି ତାର 15ରେ ହାଜିରାଟା 2015 then ହାଜିରା of accused
ଆଇୟୁ ଏକ୍ସାମିନେସନ ହେଲା ପରେ ମଧ୍ୟ 12/2/2018 ପରେ ୱିଟନେସ୍ ସମନ ହଉଛି ଦେଖୁଛି ଅର୍ଡର ସିଟ୍ ଗୁଡା ତାପରେ କୋଉ ୱିଟନେସ୍ କଣ ହେଇଛି ଅଲଗା କଥା ବଟ୍ ନୋ ପିଡବ୍ଲ୍ୟୁ ପ୍ରେଜେଣ୍ଟ ନୋ ପିଡବ୍ଲ୍ୟୁ ଏମିତି ହେଇକି ଚାଲିଛି ସେଟା ତାପରେ ହଠାତ୍ 2019 ମସିହାରେ 8/7/2019 ଗୋଟେ ଅର୍ଡର ହେଲା the petition under section 293 CRPC filed by the Lawrence is pending for consideration.
that C report probably
C report.
that is how 293 has been.
ତାପରେ ଏ ରାଇଟ୍ ଲେଟର ତା ଡେଟ୍ ହଉଛି ଅରିଜିନାଲ ପଠେଇବା ପାଇଁ କୁହାଗଲା ସି ରିପୋର୍ଟ ନଟ୍
I would think C report ରହୁଛି ପୁରା
ବହୁତ ଦିନ
ନଟ୍ ରିସିଭ୍ ଟ୍ରାଏଲ ଗଲା ଅନ୍ୟ କୋର୍ଟକୁ ଗଲା 2019 ମସିହାରେ
it was originally with the sessions and finally disposed of the sessions.
additional डेजिग्नेट करा दिया गला जे एमएलए केस सी केसेस
that is
तापरे रिमाइंडर चलला फोरेंसिक साइंस लैबोरेटरी रो ओरिजिनल रिपोर्ट पे ये चर्च ओरिजिनल रिपोर्ट 22/24
so it is
2/3/23 ରେ ଗୋଟେ ଅର୍ଡର ହେଇଛି ଯୋଉ he has filed an petition to recall the PW 10 and 11 2/3/23
by then the court didn't agree and it had completed because
yes
23 ରେ ତ 311 ରେ ଗୋଟେ ହେଲା ତ so it was taken almost day to day thereafter 20/3 13/3 27/3 it has proceeded so that period was really
yes
18 to 90 this 23 till it is transferred to the ADJ court
11% रिजेक्ट ହେଲା तापरे सेही दिन ही से देला नो फर्दर विटनेस टू बी एग्जामिन तापरे
तापर सी रिपोर्ट को न करके 293 रे सेटा नहीं गले
हां
तापरे accused is absent
has been lost press out several attempts से तेणु सेकेंडरी एविडेंस ये करा जाऊ प्रेयर कला दैट इज हाउ हियरिंग ପାଇଁ ରହିଲା
तापर 26/23 रे accused absent 6 जून टा तापर जून रे accused was also present
तापर सेटा मार्क के बेला से जो
मार्क इछि जेड पर एटा तो ये हला नहीं था
को डेट रे
on the very day 31/5
31/5 35
so once the court has come to the conclusion that the genuineness and correctness of the said document cannot be doubted why to keep it in Z in 293 it could have been marked there was no point in
जेड
Z कहीं रखले it could have been marked as how तो आसीबार नहीं ये बड़ा तो बड़ा मुश्किल है
तापरे डिफेंस पट्टी देगी जजमेंट Anything else, Mr.
Yes.
Tripathi? So, Mr. Bose, you are closing it or anything you want to say?
2 minutes, please.
Yes, please come. Please come to the mic.
My lord, the recording of the examination of the accused was on 25th March 2023. At that time, he was 78 years old. Occurred in 95. 78 years old. Memories may be weakened. This is one of mine. Secondly, my lord, if your lordship sees PW11, your lordship can gauge something from it also. My lord, at page 115, I confidentially received information regarding the illicit relations of the accused with other women, but none came forward to disclose the same to me in course of investigation. This angle was also looked into by the investigator.
That is how I put to you whether the age of the victim has been mentioned anywhere and what is the age of the accused. The age of the accused probably taking
42,
into
42
around
years.
42, 45.
Yes.
And that is why it's not very.
At the time of occurrence, you are not that aged.
No.
Yes.
Maybe that, I don't know, trial ta ସରିଲା ବେଳକୁ
ପୁରା ଅସଲ period ଟା ସେଇଟା ପଳେଇଯାଇଛି ନା 48 ରୁ probably the matter had gone to Supreme Court also. No. Somewhere it was stock. Somewhere it was stock. For quite some time. Almost 20 years it's.
No.
95ର ଘଟଣା 95ର ଘଟଣା ପରେ ଇଏ ଦେଖଉଛି ଯେ ଇଏ ସରିଯାଇଛି
ଚାର୍ଜ ଫ୍ରେମ ହଉଛି ଏତେ ଦିନ ପରେ ଚାର୍ଜ ଫ୍ରେମ ହେଇଛି 13ରେ so 95 ରୁ 13 ଚାର୍ଜ ଫ୍ରେମ ଟା ହେଇନି ଚାର୍ଜ ଫ୍ରେମ ହେଲା 2013
ମାନେ ଏମାନେ କୋଉଠି ଉପର କୋର୍ଟରେ ଚ୍ୟାଲେଞ୍ଜ କରିନାହାନ୍ତି କୋଉ
ନାଇଁ ତ
ଡେରି କଣ ପାଇଁ ହେଲା
ଆମର ତ ଏଇଠି
ଆମେ ଚାର୍ଜସିଟ୍ ଟା ତ ଇମିଡିଏଟଲି ସେଇ ବର୍ଷ ବୋଧେ ହେଇଯାଇଛି
ଚାର୍ଜସିଟ୍ ହେଇଯାଇଛି ଚାର୍ଜସିଟ୍ ହେଇଗଲା
Yes. Well, the charge sheet was submitted
in 95 I think 95 itself
मतलब 22/8/96
ঠিক আছে it's right এটা ଅଗଷ୍ଟରେ ହେଇଥିଲା this incident was in August ଆଉ ସେଟାକୁ 96ରେ ଦେଇଛନ୍ତି
and that illicit relation though not directly stated but PW2 had made one line statement that
yes
this illicit relationship and her aggravation maybe if your lordship sees PW2 she was temperamentally good but she gets aggrieved while there is a mistake. There is a one line statement by PW2
161 रे
no
how is your
by difference
deceased is my how can he say sir what was his age 30 years I don't understand
at the time of examination he was 42
he was 42
yes PW2
no he was 30 years no
42 he was examined on 25th 4th June 2014
question of PW2 no
2
2
he was examined on 24th day of June 2014 his age was 42
then
he has stated in the cross examination by defense that she was temperamentally good but she gets aggrieved while there is a mistake and the IO if your lordship sees has made that single observation in the cross examination.
That is not the case of defense anywhere. One
just I wanted to bring to your lordship's notice that maybe these were the circumstances which may have resulted in suicide.
Correct, but in the same parlance there should have been some heat up exchange of words, something like that. There is nothing. No abnormality is found in the behavior of the accused vis-a-vis the victim. So this could have been one of the consistent objection from the side of the husband probably could have triggered.
And also he states that it is a fact that PW2 had stated to me that between 9 a.m. and 9:15 the accused had shouted Podigala, Podigala. Well, the time factor is little hazy because of the efflux of time.
No, so more proximate evidence has to be taken for that.
Yes.
purpose.
And moreover,
Sporadic.
yes, and moreover,
This can't be taken.
313 statement which was there, that time the age of the accused was 78 years old.
And yes, in 23 it was 70.
Yes.
ମାନେ 2013 ମସିହାରେ କମିଟମେଣ୍ଟ ହେଲା ମାନେ ସେ
ପ୍ରୋଡକ୍ସନ ରେ ରହିଗଲା କମିଟମେଣ୍ଟ ହେଲା ମାନେ ଏକ୍ୟୁଜ ପ୍ରୋଡକ୍ସନ ହେଲା ଏକ୍ୟୁଜ ପ୍ରୋଡକ୍ସନ ନ ହେଇକି ତ ରହିବନି
ନାଇଁ ଏଇଟା 94 ମସିହାରେ ଚାର୍ଜସିଟ୍ ହେଇଗଲା
ତାପରେ ସେ
ତାପରେ ତଳ କୋର୍ଟରେ କେସ୍ ରହିଲା
ମାଜିଷ୍ଟ୍ରେଟ କୋର୍ଟରେ
ମାଜିଷ୍ଟ୍ରେଟ କୋର୍ଟରେ 1996 ମସିହାରେ ଯେତେବେଳେ ବେଲ୍ ହେଇଯାଇଛି ତାପରେ absent SR not back ଚାଲିଛି 2013 ମସିହାରେ ତାପରେ
ଚାର୍ଜ ଫ୍ରେମ୍
ନାଇଁ କମିଟମେଣ୍ଟ ଗଲା କେସ୍
ମାଜିଷ୍ଟ୍ରେଟ କୋର୍ଟରୁ ସେସନ୍ସ କୋର୍ଟ ଗଲା ସେତେବେଳେ
96 କୁ ଅନାନ୍ତୁ 2013 କୁ ଅନାନ୍ତୁ ମାନେ so we have to see it in the angle that why this has the order was passed by the Honorable Supreme Court that these four cases should be expeditiously disposed of. Because there is delay used to occur in such type of cases, where the MP or MLA, that is why. And even if the order that the High Court also is special bench is to be considered for taking of. So that's all.
Yes, madam. I'm grateful my lord has given me a long opportunity to ask
yes. Apart from that, this DCH was the second wife of that appellant. Second one.
That is on record.
Yes.
Who has said?
I
have stated.
Second.
What about
first wife died very soon at a very early age without bearing any offspring. Thereafter the second marriage, and through second marriage son, that is PW3, and the fetus was there at the time of
that cannot be taken.
No, fetus was there. That's why I said
in that case this cannot be taken abortive, as you were saying. Illicit. That cannot be taken abortive then.
And
because if the first had no upbringing,
first died very early, so there was a second marriage.
That was a natural death or
natural death?
Doubtful.
No.
If he goes down,
then my lord would have been hearing two appeals.
Depending to file anything or
I have filed the return and just supply 2 judgments more.
He filed two.
No.
I just filed some judgments which are taken on record. Are also Mr. PKP party additional standings on the hearing post and judgment.
I'm grateful, my lord. My brother will be tagging and
just give it.
I'm grateful.